D. We are going to begin as a subcommittee today. Per usual, any number of our committee members are serving on other policy committees simultaneously and are also presenting bills in assembly committees today, and that includes the chair. So I will be in and out of the room today, as will our Vice Chair, Senator Benoit, but we will keep the proceedings moving and as seamlessly as possible. I appreciate authors being here in a timely fashion. One piece of housekeeping business, which is that AB 509 by Assemblyman Anderson is pulled from today's calendar by the author, and that is then a 2-year bill. We are going to go in file order, as is our usual procedure, and I see that our first author, Senator Runner, is here, and then we're going to take up Senator Benoit's piece of legislation as he has to then make his way to the Energy Committee. Welcome, Senator Runner.
Thank you, Mr. Chair and members. I have SJR 11. SJR 11 is a respectful and very narrowly crafted resolution that urges the President and Congress to ensure that any terrorists or suspected terrorists detained in Guantanamo Bay are not allowed to enter California. SJR 11 limits itself to the concerns within our own state boundaries. Californians have the right to be concerned about both intelligence gathering and common sense, and have shown and identified that California and cities within California have been some of the top targets for terrorism in the U.S. The CIA recently confirmed reports that the 9/11 mastermind, Khalid Sheikh Mohammed, disclosed a since-aborted plan to attack Los Angeles. Also, Californians were aboard all 4 hijacked planes on September 11th, and California was the original destination of all 4 flights. Several alleged terrorists have been tried or about to be tried in the U.S. SJR 11 simply expresses the desire of most Californians that these individuals should not be tried or detained in this state. SJR 11 is supported by a bipartisan coalition of co-authors, and I'd ask for your aye vote.
Thank you, Senator. Those in support of the bill.
Mr. Chairman, members, Pete Conatee representing the American Legion. While we don't have a letter in on this SJR yet, we are in support of a similar one in the Assembly by Assemblywoman Harkey. So we would urge an aye vote.
Thank you, sir. Any other witnesses in support? In opposition?
Mr. Chairman and members, Francisco Lavaca on behalf of the American Civil Liberties
Mr.
Union.
Lavaca, before you continue, we're going to establish our quorum. I'm going to ask that the roll be called.
Okay. Leno?
Here.
Benoit? Here. Cedillo? Hancock? Huff? Steinberg? Wright?
Huff here.
Huff here.
We have our quorum. No
Thank
small
you.
doing. Please proceed.
Couple of quick points, Mr. Chairman. One, our court and our federal system is perfectly capable of holding terrorism suspects pending trial and incarcerating them if convicted. Our federal prisons are already full of and securely holding international terrorists. In fact, I read in the Washington Post recently that there are 33 international terrorists being held in federal prison in Colorado, and there's very little public notice about that. And as far as I know, there's not a big uproar in terms of holding the thousands of dangerous criminals that are held in our prisons around the country. Two, we think that all jurisdictions have a duty to help America solve the problems created by the Bush administration's failed detention policies in Guantanamo, especially if we're going to start asking other countries to accepting the remaining approximately 240 prisoners that are left in Guantanamo. And we should be doing our part to help solve to restore the rule of law and our standing in the international community. And finally, from a practical perspective, this resolution is going to do nothing with respect to resolving the issue of what to do with the remaining prisoners in Guantanamo. So we're opposed.
Very good. Anyone else wish to speak in opposition to this resolution? Do we have questions, comments from the committee? We do have a motion by Senator Benoit. Senator, I appreciate fully the intent of the resolution. I don't think this committee needs to debate the constitutional questions that the Supreme Court raised with Bush decisions to proceed with Guantanamo. That's not necessary. But just to share with you a couple of thoughts which come from the President's findings in his January 22, 2009 executive order review and disposition of individuals detained at the Guantanamo Bay Naval Base and closure of detention facilities. Under the findings, it says, it is in the interests of the United States that the executive branch conduct a prompt and thorough review of the circumstances of the individuals currently detained at Guantanamo. So I think that is a supportable statement. And then in Section 4, immediate review of all Guantanamo detentions, point 5, it says consideration of issues relating to transfer to the United States. And it says the review shall identify and consider legal, logistical, and security issues relating to the potential transfer of individuals currently detained at Guantanamo to facilities within the United States. And the review participants shall work with the Congress on any legislation that may be appropriate. So I don't think the federal government, in fact, I believe firmly, is not going to act in any cavalier fashion or not be concerned with the same concerns that are expressed in your resolution. So for those reasons, I won't be supporting it.
And I agree in terms of some of the comments we've been hearing from Congress and also from the President. I think the point would be that, as you all well know, we very often speak for the people of California in our resolutions to Congress and to the President. We have a role and a job. And I believe that certainly we appreciate when we see indications going one way or the other. But that does not necessarily take away our job and our role to speak for our citizens. I believe this is a strong position that many of my constituents have, and quite frankly, many of your constituents too. So I'd ask for an aye vote.
Very good. We will call the roll.
Leno?
No.
Leno, no. Benoit? Aye. Benoit, aye. Cedillo? Hancock? Huff? Huff, aye. Steinberg? Wright?
We will
Thank you.
keep the roll open.
Thank you.
We're winning so far.
Vote is 2-1. Other members will be joining. Senator Benoit, you have item number 2.
Mr. Chairman, with all due respect, would you mind if we went ahead and heard Mr. Fuhr's bill first? I have an interest in that bill, and then I could go immediately thereafter. I see he's in the room.
That is item number 3.
Yes.
So Assemblyman Fuhr is our next author.
I prefer to think of myself as your next guest, but I'll settle for author. That's fine.
You have item number 3, but you also have item number 10. So we'll start with 3, which is the issue of interest for Senator Benoit.
Very well. Thank you very much, Mr. Chair, members of the committee. This bill, which is the product of 2 years' worth of work on my behalf, and perhaps prior authors have dealt with this issue for even longer, is about one of the most important public safety issues in our state. And the bill is here because there's something we can do about that issue. Every year in California, we have more than 200,000 people arrested for driving under the influence. What's even more astonishing is 45,000 of those people have been convicted of drunk driving before. The problem of recidivism is huge, and the consequences for the people of our state in terms of public safety are enormous. More than 1,500 people died at the hands of drunk drivers in the last year for which we have records. So this bill is here to try to address that issue of repeat drunk driving. And it's based on science. It's based on the experience of other states around the country that have dealt with the new technology that this bill seeks to bring to the first-time offender. The bill says that if you are a first-time offender convicted of drunk driving, that instead of the restricted license for which you are otherwise eligible to apply, you would have an ignition interlock device installed on your car. The ignition interlock device is very simple. If you have to exhale into it before the car will start. If you are inebriated, the car will not start. This approach has 2 benefits. First, during the period in which the ignition interlock is installed, the person can only drive sober. So we know during that period that the streets of California are that much safer. But more than that, we know from experience in states like New Mexico, which have had ignition interlock devices in place for a while now, that the rate of repeat drunk driving declines. And why is that? Because the offender gets in the habit of driving in a sober way, and that habit continues long after the IID has left that person's vehicle. So the purpose of this bill is very straightforward. Let's have in place this approach and reduce repeat drunk driving. We know the stakes are very high here in Sacramento, and indeed throughout the state there is incident after incident of the tragedy of drunk driving destroying people's families. There are at least 4 editorials throughout the state of California in major newspapers supporting this measure. It's a bipartisan bill. It has had no votes throughout its process. It was 77-0 on the floor of the state assembly. The last thing I'll say is this. Last year, I brought forward a bill that would have mandated first-time offenders have ignition unlock devices to reduce repeat drunk driving throughout the state of California. This bill is a more targeted approach in light of some of the concerns that the chair previously has expressed. So this year, this approach would be confined to a pilot project. It'd be confined to 3 counties in the state. There'd be a sunset of the bill. There'd be a study to determine the efficacy of this approach. And unlike previous bills, this bill comes with its own startup funding. In the Assembly, I actually proposed an amendment, given our fiscal situation, that would say that this bill only would be implemented if there were outside funding available to assure the startup costs to DMV were 0. We then have obtained a commitment from the federal government that there be that funding. So it is cost neutral to the state. It will have a tremendous benefit in keeping our streets safer. It's a pilot project that will demonstrate throughout the nation that this is an effective approach, and I urge your aye vote.
Thank you, Assemblyman Feuer. I hear your passion, and I know your commitment and your tenacity, your significant tenacity in authoring this piece of legislation. And we've had many conversations over a many-year period of time. And I've been pleased to work with you. I'm going to allow for testimony. We've got a significantly long calendar today, so it's slightly uncommon in this committee that we limit testimony to 2 and then have others identify their support or opposition and organizations. So I'm not going to run a clock on you. Keep it about 2 to 3 minutes, whoever the 2 identified are, and then we'll proceed.
We're prepared to move forward just like that. Mary, do you want to begin?
Thank you for hearing us today, Senator Leno. My name is Mary Klotzbach. I am a nurse at John Muir Medical Center in Walnut Creek, California. I've worked in the trauma room for 21 years. I've seen the results of drunk driving, and unfortunately 8 years ago this July, my son was killed and I was in the car with him by a DUI offender. We use technology every day to save lives. This is using technology to save lives. California spends $12.4 billion a year on DUI crashes alone, something we don't need to do. I ask that you support this bill.
Thank you very much for being with us today.
Mr. Chair and members of the committee, Captain Avery Brown with the California Highway Patrol. On behalf of Commissioner Joe Farrow, the Highway Patrol is proud to support this measure and this bill. We believe that it will provide a manner to reduce recidivism by requiring persons convicted of DUI to install an ignition interlock device in any vehicle owned or operated by the offender as a condition of being issued a restricted driver's license. To bring it more home to the committee and add some realism to it, we find that in the state of California, when you total up the second-time offender, the third-time offender, and the fourth-time offender, we come up with a number of about 41,866 violators. We take that number away from the total individuals arrested, 203,866 in the state, and we find that our violators, our first-time violators, account for 162,000 people a year in the state of California. 16% of that 203,000 will reoffend. Tragedies on our roadways. Less than 48 hours ago, a young man who violated in 2007, plea bargained to a wet reckless, got his privilege back, drove, was involved in a collision, and today his wife and 2 children are dead. We have to do something more to curb drunk driving. The current process of allowing a person to say, I will not drive, I will do my suspension, get my license back, and go back out on the road is not working. They're reoffending, and we ask for your support.
Thank you, Captain, for your testimony. So others, if you could identify yourselves and your position.
Mr. Chairman, members, Randy Perry there and Reed & Associates on behalf of PORAC, and we're in full support of this bill.
Thank you, Mr. Perry.
Good morning, Mr. Chairman and members. Lieutenant Wayne Billowit on behalf of the Los Angeles County Sheriff's Department in full support of the bill.
Thank you, Lieutenant.
Tim Yarian, representing the Association for Los Angeles Deputy Sheriffs, the Riverside Sheriff's Association, and the Los Angeles Police Protective League. We are also in full support.
Thank you, Mr. Yarian.
Al Cooper, representing Sacramento County Sheriff's Department, and we are very happy to be one of the test counties. Thank you.
Thank you, Mr. Cooper.
Mr. Chairman, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office in strong support.
Thank you, Mr. Filizzato. Others in support?
Yes, good morning. Lieutenant Barbara Ferguson, San Bernardino County Sheriff's Department in support.
Good to see you, Lieutenant. Thank you.
Sylvia Solisha on behalf of the City of Los Angeles in support.
Thank you. Quite a bit of support. Anyone else? If there is any oppositional voice, please step forward.
Mr. Chair,
Yes.
while the opposition is moving forward, I omitted to discuss amendments, and if I might at this moment do that, if it's the pleasure of the Chair?
Why don't we go through the opposition, then we'll get to all of them.
Okay, very well.
Full discussion of that.
Good morning, Mr. Chair and Senators. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice and also the California DUI Lawyers Association. We are opposed to the bill. And let me be clear, our position is not somehow support of drinking and driving, which has been represented in some of the lobbying efforts in the Capitol in the last couple of weeks. Our position is that we really need to look at this policy proposal and its flaws. Right now, under current law, if a judge believes that someone deserves to have an interlock device on his or her vehicle, the judge can order that. Just this past year, a new law took effect last week to give the DMV greater oversight of installing interlock devices. They did that because there was an argument that judges weren't ordering them enough. So now we've taken steps to ensure that the worst of the worst, those offenders who are the highest risk, as the judges look at them eye to eye and make that decision, have interlock devices. That's current law. What this bill does would impose it on the 97% of other drivers who will not commit another offense in the time period that's being addressed by this bill. Less than 3% of first-time offenders will reoffend within 6 months. That's what this bill covers. That 97%, those ones that the judges have decided do not deserve to have an interlock device. All we're asking is to really look at the justification for that. None of us want injuries or fatalities as a result of drunk driving, but this bill does not cover it. Even if you look at over a long period of time, I think 13 to 15 years out, nearly 80% of first offenders will never reoffend. And yet we're talking about imposing it on 100% of first offenders. The DMV's own studies have said this is not the way to go. The DMV has also said we should focus on second offenders, which we know Senator Huff's bill addresses. This is counter to what the DMV studies have shown will work. So unless you're targeting those that are really at risk, this bill is overreaching. There are a number of problems with interlock devices as well. We haven't had a full discussion on this bill in terms of the problems with interlock devices. Interlock companies concede that certain foods will trigger a false positive. Altoids will trigger a false positive. Mouthwash will trigger a false positive. We haven't had a full discussion as to what kind of interlock devices we are going to be sending out into these counties under this bill to see if they really work, to see what the problems are, and to see who will be impacted by this bill. One of our concerns is that there will be two standards of interlock devices. We all know that there are better interlock devices than others because of the types of technology. We're concerned that those who can't afford under the sliding scale will pay less for interlock devices, will get the second tier interlock devices that have greater risk of false positives. So all of these issues have to be looked at more thoroughly before this bill goes forward. We ask that you hold it. I'll turn it over to the next witness now. Thank you.
Thank you, Mr. Hernandez.
Good morning, Senator Leno, Senators. My name is Bruce Kapsack. I am a 15-year DUI specialist attorney, defense attorney. I am one of the founding members of the National College for DUI Defense, and I write one of the nationwide books on DUI. And I'm here to tell you that this bill targets the wrong people. As was just mentioned, The real issue here are the hardcore drinking, driving individuals. Those are not your first offenders. The statistics that were just read to you indicated that somewhere in the neighborhood of 170,000 first offenders will never come back through the system. Yet all 170,000 of them are going to be put to the financial cost of installing this ignition interlock device. And what I can tell you in all my years and approximately 4,000 clients that I've represented, the people that this is going to hurt the most are the people who are not going to be able to afford an ignition interlock device and are going to drive anyway. And that's just going to lead to the next problem, which is driving on a suspended license, which is then going to hit them in their pocketbook again and again and again. And it's going to be a huge financial issue for those individuals when you're not really catching the people you want to catch. As was stated, the number of first offenders who repeat is somewhere in the neighborhood of 2 or 3%. The greater percentage are your second and third offenders who keep repeating, your true chronic alcoholics, who, as long as they have access to a car, are going to take a chance regardless. But what I think is better is to look at those people. Right now, a second offender can obtain their license back after, as we put it, sitting on the sidelines for a year. Then maybe they slap an ignition interlock device on their car. What would make more sense, as was indicated by the author of the bill, to try and get a pattern of non-drinking would be to put that ignition interlock device on a second offender earlier on. Give them the opportunity to get their license back earlier with this reinforced behavior. But on a first offender, I don't think truly an alcoholic is going to be affected by an ignition interlock device that does have these fail-safe problems. And I'm here to tell you, I've represented a number of individuals where, let's just put it this way, the shade of the lipstick on the ignition interlock device did not match my client's shade. Anybody can blow in that machine. When you're talking a second offender who has to have someone do that for a year, that's hard. But when you're talking a first offender who only needs to have that done maybe once or twice, if they're a repeat alcoholic, it's easy for them to do. This is not going to solve the problem. It's going to lead to an overwhelming number of driving on a suspended licenses. And as was said, since I'm trained on every breath machine used in the state of California, by the manufacturers mostly, the ignition interlock device is not alcohol specific, and it's going to have some problems with false positives. People who didn't drink and drive. You're driving down the road, you tested fine, you pop an Altoid in your mouth because you're coming home to your wife or something like that, or you had a cigarette, that device goes off, you've got to pull over and blow on it. And there's a problem with that. There's going to be people cutting across 8 lanes of highway because they have to blow back into this machine because it registered a false positive.
Thank you, Mr. Kapsak.
Thank you.
Liberty Sanchez on behalf of the California Public Defenders Association, also in opposition for the reasons previously stated.
Thank you, Ms. Sanchez. So I'm going to ask if you can respond to some of the oppositional concerns, but before that, why don't we review the amendments that we're considering?
Yes, Mr. Chair, I am pleased to accept the amendments that you and I have discussed, and let me delineate them now so everybody is clear. Adding a rural county to the pilot project. I mentioned that I know Mr. Benoit has an interest in Riverside. Extending the duration of the pilot project. The pilot program will be extended to a 6-year period of time, and making this bill's enactment contingent on the enactment of SB 598 by your colleague, our Senator Huff. Those are the amendments that I am pleased to take this morning. With regard to the testimony that has just been offered, I do have a few things I'd like to say. If it would please the Chair, the Judicial Council is represented here this morning, prepared to come forward and state that it does not view this bill as any inhibition on judicial discretion. If it would please the Chair, the Department of Motor Vehicles is here to say that the study to which reference was made, performed by DMV, was in fact flawed. And the consequences of that would lead one to conclude that, in fact, this bill makes sense. If it would please the Chair, I could continue and delineate a few other points in opposition to what these gentlemen just stated in their testimony. The first thing I would say is if there are flaws in ignition interlock devices, those flaws exist now. IIDs are employed under California law right now. So the argument sweeps much too broadly. We already rely on IIDs. And presumably, we do so because we believe that they have efficacy. What this bill does is test an expansion of their use to first-time offenders.
Mr. Fiore, on that point,
yes.
Should we go forward with this pilot project and with the scheme that you've designed out of concern for low-wage earners who may be a part of it, so that there is a sliding scale and those who are at poverty are going to pay just, I think it's 10%?
Yes.
How can we ensure that they're not going to get a substandard or a lower standard piece of equipment? I like the scheme, but I want to make sure everyone's getting equal equipment.
I think it would be easy.
I hadn't heard that before, so that
yes, I think it'd be easy for the DMV to simply require of the IADs, the manufacturers who are installing them, to have some kind of report that states the model or something of the IAD that was installed on the vehicle to assure uniformity and the quality of the product.
I think we might want to consider that as an amendment.
I'm fine with that. What I want to be sure we do with amendments, as we've discussed, is to, in this fiscal climate, do nothing that amounts to a poison pill in the bill from a financial standpoint.
I'm not looking for that.
I know you're not, and
Yeah.
I just want to be clear. So,
Sure.
having the installer simply submit to DMV electronically something that verifies the model number, that's fine with me.
Sure.
With regard to a couple of the points that were made, there is a false assumption that underlies much of the testimony in opposition to this bill, and that is that the first-time offender was just somebody who casually had a drink at a party someplace. And it really mirrors a national campaign that was waged against ignition interlock devices last year by the alcohol industry, which ran a full-page ad when this bill was being promoted on a larger scale last year in USA Today. It depicted a photograph of Lindsay Lohan, and it said, IIDs are good for Lindsay Lohan photograph, but bad for picture of people toasting at weddings. Here's the flaw in the alcohol industry's argument. The flaw is that insurance industry analyses show that a first-time drunk driving offender has typically driven drunk 87 times. This is not a casual drinker who is involved in this situation, and toasting at a wedding does not make someone sufficiently inebriated to be under the influence when they're driving.
Could you repeat how we know that 87-time figure?
There's an insurance industry study that states that. And it's a study, by the way, that has been employed with success by Mothers Against Drunk Driving and others who advocate for this approach in other states around the country, including New Mexico.
I'm always just slightly suspect of an industry study, but I'll take it on its face
It's an
value.
insurance industry study, not an ignition interlock industry study.
I understand, but that impacts rates. So, I just want to clarify or allow for the opportunity to clarify what this contingent enactment of the Huff bill actually means. So I am a co-author of Senator Huff's bill, but I don't know it as detailed as you. So if you want to just share with all of us the program that your bill would mandate with regard to the second-time offender.
My question.
The short version of the bill is that it allows somebody to voluntarily enter the program, and it reduces their time that they have to get them back into a car quicker. But to do that, they have to breathe in a device. So it shortens the time that they're not able to do it. So it
offers second-time offenders an incentive.
Exactly. Second and third time, it's an incentive. It shortens their time to get back legally into a car, because statistics show only 10% of those mandated to not drive are not driving. The rest of them are out there driving. And it's a huge population of people that has suspended licenses that it's too inconvenient to the family or whatever else, so they're out there driving. And mine gives them an avenue legally to do that. And there's a behavior modification thing that does take place as they're breathing into this, and it does change behavior.
Very good. Thank you, Senator. We have a number of committee members who wish to speak. We're going to start with Senator Cedillo, then Senator Wright, and Senator Benoit.
I was going to ask him just to distinguish between the two and note how, well, obviously my concern is that there's an overreach here, and that to get 3%, you're picking up 97%. And that's just my concern.
I think, with due respect, Mr. Cedillo, the 3%, I think that analysis misses a key point. And again, one can look at the efficacy of this approach in other jurisdictions. If one looks at New Mexico, for example, and this goes to the other point that was made earlier about unintended consequences, because if you're concerned about overreaching, really concerned about unintended consequences. There were concerns expressed about offenders circumventing the process altogether. Well, if that were the case, this approach wouldn't have met with the success it has elsewhere. So I don't think that the notion that we're simply trying to get to a small percentage of the offenders is right here. And again, 45,000 repeat drunk drivers arrested in California every year. We have clearly the current situation, the status quo, isn't working. We can do better. We have very few opportunities as legislators to take actions that will literally save people's lives. I will say I debated this issue with a representative from the alcohol industry on National Public Radio a couple months ago. And
that's interesting. You're not going to my point.
Okay.
You're going off point.
Well, except I do want to say this is on point. The claim was made that if in New Mexico there was a 60% rate of reduction in recidivism across the board, not for 3%, across the board, would that be sufficient to replicate in California? The industry representative said that meant 40% of people were repeat offenders. 60% isn't good enough. I think if you could ask the families of the 1,500 people who lost loved ones in the last year for which we have records, if a 60% reduction in that rate of loss of life would be a good thing, they'd all say yes.
Senator Wright.
I think Senator Cedillo raised some of my concerns. I can't vote for this today. My concern becomes several. Under current law, you're right, a judge can, should he or she choose, require the device be mandated. One of my concerns, as I indicated to you, is that I don't think we should ever have a policy that in the event someone doesn't buy a vendor's product, that they lose their privilege to drive for life. Now, a judge can do that now, but the judge only does that in a fraction of the cases where the drunk driver was egregious. We're now going to extend something that occurs to 3 or 4% of the drivers to all of the drivers. Again, the first-time offenders' recidivism rate is about 25%. So we're talking about imposing a statute that in effect will, at the maximum, it's only going to have a 25%, because 75% of the first-time drunk drivers don't recidivate. The judge can now make a determination. I mean, and I would even support if you said if the blood alcohol content was over a certain amount that it be mandated. But I could have a guy who was at the minimum who was stopped slightly over the limit. He's drunk. That person should have an option of saying, I want my license suspended. It should not be that he automatically loses his license for life if he chooses not to have the device installed. That's one of the concerns that I have. The other concern that I have is, again, as we look at programs like this, as we begin to define success, I don't think anyone would say, oh, I want to see people get killed drunk driving. I don't think that myself or anyone who votes no. I think at the end of the day, given the cost that we're going to impose on people, and we can make an argument, again, we're not talking about the whole $12 billion because only a fraction of those people currently do that. The judge has the option right now of doing this in cases that are egregious. If this said if the blood alcohol content was over a certain level, that would make me a yes. If the bill said that the person had the option of having his license revoked, or not revoked, but suspended for up to a year, that would make me vote for it. But to say to someone, and again, the amount of discount that goes to people who are in poverty. See, again, I represent a whole lot of poor people, and I understand that you worked for poor people when you were at Betzedek. I've got people in my district who aren't going to be able to register their car because we just raised their VLF. So in my district in Watson-Compton, I've got a percentage of people whose cars are going to be impounded because they'll never be able to afford the VLF fee that we just impounded. So now at a minimum, I mean, the percentage of poverty gets you to a family of 4 at 66 grand. Even at the 66 grand level, you come out at somewhere between $300 to $700 annually, even with the discount that you propose. So because of the cost, because of the lifetime ban, because of the fact that such a small percentage recidivate, because the judge already has the authority to require the device in cases that were more egregious, I can't support it today.
Mr. Chair, if I might respond very concisely, please.
If you could, precisely.
Yes. First, I want to underscore that what's before us today is a pilot project with a sunset and an analysis to be done on its efficacy. So that if one were concerned about the long-term consequences of this, in fact, this is a short-term approach, the life of which is extended actually at the behest of the committee, in order to see if it works as well as we anticipate it will. Second, on the blood alcohol point, we've already made the determination as a policy matter in our state that .08 and above is a dangerous level. And in fact, as testimony to that, we heard from Ms. Klotzbach, whose son was killed by a drunk driver who was at .09. So the argument that ought to be raised to a different level, I think, is met with the facts on the ground right now. Regarding the low-income protection built into the bill, as we've discussed, when judges impose emission interlock device requirements now, they're doing so under a regime in California that is not nearly as protective of low-income people as this bill would be. The protections built into this bill are much more substantial, and if anything, raise concerns by the interlock companies that it's too substantial reduction. So right now, people in poverty assigned to have interlock devices on their car in California could be in the position you're describing. This bill assures that much smaller percentage of those people will be in that kind of jeopardy because it is so much more protective of them and not at a nickel of public expense. Thank you, Mr. Chair.
Thank you.
But see, the concern I have now is that, again, if we're playing statistics, I would submit to you that most of the people who commit fatal accidents probably weren't drunk. So if that's where we're going, the saving of lives, again, it's not to say that we should, but judges make a determination if someone was, just sloshy drunk, and they can do that now. And frankly, for that guy who showed up with a point or 1 point or something like that, he perhaps should have his license revoked forever. I don't have a quarrel with that. And the fact that we treat them all in the blanket sense gives me pause. Again, judges now look at the situation and evaluate it on a case-by-case basis. They make that determination right now on about 8% of the first-time cases. So I'm not uncomfortable with a judge being able to do that because he's actually looking at the facts and not making a blanket charge or a blanket on anyone. So again, the problem for me, and again, the bill may move. I'm just one vote here, and obviously I'm not afraid to be the lone no vote if it gets to that. The concern I have is that I think that it does in fact hugely disadvantage poor people. We just flatly disagree with that, and so we won't resolve that. I think it's a huge disadvantage to poor people. I think that given that the 25% of first-time drunk drivers recidivate, that we're capturing far too many people and the net's far too broad for 25%. Again, the concern I have is that if your bill said at some ratio that is currently done that we're not requiring all people to lose their license if they don't buy the device, or if the person had the option of simply saying, suspend my license. Your bill doesn't even give the poor person the option of saying, I'll park my car and I won't drive. Your bill says if a poor person doesn't get this device, he is unable to drive for life. I find that objectionable.
No, actually, they can certify that the car is not operable and then have access to a vehicle, and then they don't have to take that device.
No,
thank you, Mr. Chair.
He can't get a license for life. If he can't get a license in California, he can't legally drive. So your bill says, which is consistent in part with current law, you're absolutely correct. Your bill says that if I don't put this device on my car, that I am unable to drive for life. I can drive, obviously, but I can't drive legally. That becomes the concern I have, sir.
Senator Benoit.
Thank you, and I would take a little different approach. I'm very much in support of the bill. I believe that this has been shown to be effective in other places, and I believe that Riverside County would be a good test county because it does include a significant rural component as well as being a very high DUI area, and would support that amendment. You know, I spent a number of years as a highway patrolman driving the LA freeways and arresting folks for driving under the influence, probably estimated about 1,000 driving under the influence arrests. And what I would like to add is that the insurance study that cites the 87 times prior to the first arrest is obviously a guesstimate. But I can tell you with a lot of experience that most everybody I stopped, it wasn't their first time driving under the influence. I would love to think I was that good, or that we had enough officers out there that could do that. The truth of the matter is, if you stop somebody who's a .10 or a .15, even a .08, they've drunk a lot, and people don't, not average people don't drink that much. And if they have drank that much tonight, and you caught them, it's not usually the first night they ever had that much to drink. 87, maybe it's 50. Maybe it's more. I don't know, but I know it's not a first-time offender that we're talking about. And I know that while most don't reoffend, the mother of the and two kids that were killed that the CHP cited 2 days ago, they were a part of that 97%. He hadn't been caught yet again. He hadn't had his second violation. He had had his first. The rest of the family's gone as a result.
That's right.
That's why I think steps that we take, even that may seem a little onerous in some communities, steps that we take to prevent that kind of tragedy from reoccurring are rational, reasonable steps in the right direction, and that this bill merits serious consideration and I believe strong support. And I commend the author for bringing it forward, and I sincerely hope it passes with those amendments. Thank you, sir.
Thank you, Mr. Benoit. We're going to try and wrap this up because we do have a long calendar, and I think we've had a very healthy debate. Of course, Senator Huff.
Yeah, and I'll just keep it brief. This is obviously an issue that's of concern to me. I have a parallel bill, although it takes a different tack at trying to solve the problem. I have been struggling with the .08 level. You know, my bill initially started at .5 when you're mandating something. But I just want to say briefly, with the amendments you've taken and it being a pilot program, I will support your bill today.
Thank you, Mr. Huff.
Thank you, Senator. So just to share some of my thoughts with you, Assemblyman, and also with those who are listening, I have had consistently over time a concern for many of the reasons expressed by the oppositional voices and some of our colleagues on the committee with the mandate for first-time offenders. I know the DMV is here to possibly counter what their 2005 report says, but it says the results of this outcome study clearly show that IIDs are not effective in reducing DUI convictions or incidents for first-time DUI offenders, even those with high BACs at arrest. Maybe the study was flawed. Maybe the random wasn't perfectly right. We know the numbers can tell us things that may not be so. So we have had our disagreements over the years. I adamantly could not support your bill in prior versions because of that. Given the seriousness of the issue, that we are talking about life and death, I think you're very earnest in your efforts. I don't think you're trying to be onerous, and I think you are of full mental capacity to understand what unintended onerous consequences are. You've thought this through. And because we're talking about life and death, I don't want to suggest I know for fact, unequivocally, that this will not benefit anybody on first-time offenders. So I think this is a very thoughtful, and I think there's some wisdom to this approach, that we do double join it to Senator Huff's bill, which will be a statewide program with the incentive for second-time offenders. And that will be ongoing. We're going to overlay that with a pilot project, which will go for 6 years. And after that time, it will sunset, but with non-state dollars, we will be able to compare county to county and really get a sense of whether this is beneficial or if it has had the onerous unintended consequences or what the results are. And we as legislators, or those who succeed us, will be able to look at that. So for those reasons, I can support it. And I just want to review some of these amendments. Because of my slight ambivalence, I'm not eager to see this expanded much beyond the way it left the Assembly. I also don't want to begin mixing and matching counties. I know there are those who want to keep Sacramento in, want to keep Alameda in, want to keep Los Angeles in. And I appreciate Senator Benoit's interest in Riverside, but the population's a little larger there than I would like to see it expanded to. So I think Tulare might be a good rural county where there are high conviction rates, so we'll get the same kind of snapshot that we do with Riverside, but not as large of a population, because I'm not interested in seeing this expanded much beyond the 3. And you are accurate. We'll extend the sunset and study 1 year, which will make it a 6-year total pilot project, contingent upon enactment of Senator Huff's bill. and that the studies will compare 4 counties under the Huff bill. And I don't know what we do about, and I'm happy if anyone's got any kind of suggestions here, comparing quality of equipment from maker to maker. I wouldn't want to lock in a particular definition that's going to make it sole source, but at the same time, how do we compare one maker? Sure, Senator Benoit.
I would suggest that the existing IID laws must have a approved list of devices that meet a minimum criteria.
Mr. Kapsak, you seem probably our resident expert on this. If you could share.
There is a both federal and state approved devices. And to answer your question, I think if there's going to be a pilot study, then one of the easiest pieces of data to obtain would be the number of false positives. In other words, the number of times that one of these devices triggered, either on initial startup or during the drive, and the minimum time was needed for the reset, and then it allowed the driving. That would be an indication that it obtained some kind of false positive, because there's no physiological way for a person to go from a .04 to a .00 in the 3 minutes that's the normal reset.
Right.
So if you looked at how many false positives and then tied it down and said, oh, it's manufacturer A who has the machine, then you know manufacturer A has an inferior product.
That's a great idea. That's a great idea. Because what I wouldn't like to see is that constituents of Senator Wright get one model and that another member's constituents who can afford to pay it all themselves get a different kind of model.
I would point out that, again, the Vehicle Code does currently specify performance standards for interlock devices with which manufacturers must comply.
All right. Well, with that one tweak, that probably is a good addition to it. So,
and if I could, I'd
Senator?
like to be added in the amendments as a co-author.
Okay.
Thank you, Mr. Berlin.
Yes.
So then,
and I move the bill as amended.
Thank you. As amended, without objection, we'll take those amendments. And if you'd like a brief close.
Urge your aye vote.
Thank you, sir. We'll call the roll.
Leno?
Aye.
Leno, aye. Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Huff? Huff, aye. Steinberg? Wright?
You have 3 votes. You need 4. We'll put it on call.
Thank you, Mr. Chair, members of the committee.
Thank all of you for your assistance.
Of course.
Yes, and you have item number 10.
Well, actually, no, I want to defer to Senator Benoit for his bill, and then I'll come back.
Okay, great. We're back to item 2, Senator Benoit's SJR number 12.
Thank you, Mr. Chairman, members of the committee. SJR 12 deals with the State Criminal Alien Assistance Program reimbursement. The SCAPA, as it's referred to, was initiated in 1994. The program was created in order to reimburse states and counties for the costs of housing incarcerated, undocumented criminal aliens in their state prisons and jails. Federal law states that when a chief executive officer of a state submits a written request to the United States Attorney General for reimbursement, the Attorney General will enter into a contractual agreement that provides for compensation to the state to incarcerate the undocumented criminal alien. On May 7th of this year, President Obama released his proposed budget for fiscal year 2010, and that budget eliminated the funding for numerous programs, but eliminated SCAPA entirely. According to the statistics obtained by the United States Department of Justice, undocumented aliens comprise 12% of the state's current prison population. In California's costs in 2008-9 were just short of $1 billion in this area. The federal government reimbursement was $111 million. That's clearly well below our costs. Since 2000, when SCAPA was first instituted, California's cost to incarcerate people here who were here illegally at the time they committed the crime has been over $9 billion. SJR 12 simply calls upon the Congress and the President of the United States to restore funding for the State Criminal Alien Assistance Program in the 2010 fiscal year. I have here in support Mr. Craig Brown from the CCPOA, and I'd like to hear if you could briefly.
Mr. Brown, welcome.
Craig Brown from the California Correctional Peace Officers Association. We support this. We've supported this since 1992 or 3 when it was first thought of, and every dollar you get from the federal government is a dollar of general fund savings.
Thank you, sir. Anyone else in support, in opposition to SJR 12? Any comments or questions from the committee? If you'd like to close.
This bill has received bipartisan support. The issue, I think, is not a partisan issue. California deserves to get more than it's getting currently back from the federal government. This is an area where they could easily help to right that imbalance. I urge your support.
Very good. We do have a motion. I would agree with you. I don't think this is a partisan issue, and I do believe that the federal government owes us significant amounts of money, which would certainly help us sustain Cal grants, our park system, any number of other issues. So I will be supporting it. I have to say, and I don't know if this causes you any concern, I know that the program itself is called the State Criminal Alien Assistance Program, but it was came into being some years ago, and we have, I think, a greater and higher level of consciousness around these issues today. I don't know why the word alien needs to be repeated in the resolution itself. That undocumented clearly acknowledges the population that we're talking about, criminal, undocumented. So if we might delete alien just from the wording, I know we're not going to take it out of the program name.
Sir, that's the will of the chair, I understand.
I think it's just unnecessary, and we know the power of words.
The federal government's a little slower to...
Yes, okay. Yes. So if with that amendment, Mr. Huff, so with that small amendment? Very good. Senator Cedillo?
Yes, let me, I appreciate that. I want to thank you, thank the author. I'm still looking at this. I'm not going to vote for it at this moment, but it doesn't preclude me from voting for it when it hits the floor. I know that we, part of the governor's presentation was that he was going to come into Sacramento and then go to Washington and be the collectinator, I think was the phrase he used, and going to bring us all the resources.
Among others.
Yes, and clearly if the federal government owes us money, they should pay us. I know some people are concerned about the exact amount, and that doesn't exactly concern me. So I thank you for making that change, and while I won't vote for it at this moment, I'm looking at it to make sure that it is something that I can vote for on the floor, and I remain open for that.
We welcome your support, sir.
Thank you, Senator Cedillo. So as amended, we will call the roll.
Leno?
Aye.
Leno, aye. Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Huff? Aye. Huff, aye. Steinberg? Wright?
We will place the bill on call. Thank you, Senator. I understand you have to go to committee. We'll see you a bit later. We'll return to our previous presenter,
yes,
author.
Meaningfully less controversial measure.
Assemblyman Feuer, welcome back. This is item number 10, which is AB 653.
Yes, thank you very much, Mr. Chair. This is a bill that, it's again a bipartisan bill, no votes, been on consent in previous committees, very straightforward. There was a court ruling several months ago which for the first time indicated that the marital privilege that pertains to all of us is not available to peace officers when they're involved in administrative hearings. A situation in which a wife who's both members of the couple are in law enforcement, a wife was disciplined for failing to report on marital communications to her superiors. The result of that has been a real uproar in the law enforcement community, and as is reflected in the analysis, there is no opposition to the measure and strong support from not only the peace officer on the street, but also from superiors like chiefs and others. So what the bill does is it restores that privilege, makes very clear the privilege exists, but it does specify exceptions, for example, when there are exigent circumstances, when public safety is at stake, and so forth. It's a good balance, and again, no opposition. Urge your support this morning.
Thank you, Assemblyman. In support.
Tim Yarian, representing the Association for Los Angeles Deputy Sheriffs, the Los Angeles Police Protective League, the Riverside Sheriffs Association, and the Los Angeles Probation Officers Union, AFSCME Local 685. John Lovell had to take his wife to the doctors today, so he called me this morning, and he asked if I could also testify in support for the California Police Chiefs Association, the California Peace Officers Association, and the California Narcotics Officers Association. Briefly, this is something we have sat down with the management groups and worked this out, and I think we've got a good compromise. I hate to use the word happy marriage, but I think that's where we are. I urge your support.
As my father would say, good gesund. Thank you, Mr. Yari. I appreciate your testimony.
Mr. Chairman, Senators, I'm Jim Votes on behalf of the LA County Professional Peace Officers Association, the police officer associations from both Long Beach and Santa Ana, and the California Fraternal Order of Police, all in strong support.
Thank you, Mr. Votes.
Mr. Chairman, members, Randy Perry there and Reed and Associates on behalf of PORAC and the California Association of Highway Patrol in support.
Thank you, Mr. Perry. Any opposition? We don't believe there is any, but if you wish to, this would be the time. Looks like there is not. I would agree with Mr. Yari, and this is a good marriage. Finds that fine line, and so I'll be happy to support it. We have a motion by Mr. Huff.
That's right.
And we will, if you'd like to close, we'll call the roll.
This may be the first time these hallowed halls have heard the word gesund. And with that, I urge an aye vote.
All right. Roll, please.
Leno?
Aye.
Leno, aye. Benoit? Cedillo? Cedillo, aye. Hancock? Huff? Huff, aye. Steinberg? Wright?
You'll have the votes. We'll put it on call.
Thank you, Mr.
And thank you for your time today. I see Ms. Carter is with us. You're our next author. This is item number 4, AB 237, not overlooking the fact that we have a very patient Mr. Cook with us. If there's not another author, you would be next. Oh, but I think Mr. Fuentes is here, but he comes after Cook. So, Ms. Carter, welcome.
Thank you, Mr. Chair and members. I'm here to present AB 237. AB 237 will strengthen metal theft enforcement by allowing uniformed city police officers and county sheriffs trained in theft investigations to pull over suspected metal thieves. This is in addition to the CHP. Metal theft is one of the crimes of the century. Stolen metal is transported on back roads and streets where the CHP cannot always catch the thieves. AB 237 helps us stay 2 steps ahead of the criminals. Utility companies, construction sites, farmers, and schools are constantly fighting a losing battle against metal theft, and we as consumers are asked to pay the price. Local police officers and sheriffs who are trained in theft investigation know exactly what to look for when searching for metal theft. This bill does not allow police to effect a vehicle stop based on the simple presence of metal products. Further, this bill does not infringe upon anyone's right to travel and does not infringe upon the Fourth Amendment. I have with me today Lieutenant Barbara Ferguson of the San Bernardino County Sheriff's Department to testify on this bill, and I ask for an aye vote.
Thank you, Assemblywoman. Welcome.
Good morning. I'm Lieutenant Barbara Ferguson from San Bernardino County Sheriff's Department. We're the sponsors of this bill, and it's got statewide support. I just want to reiterate that the bill is narrowly crafted specifically for police and sheriff's deputies who are specifically trained in theft investigations. And as Assemblywoman Carter said, that the sheriffs and police officers are out on surface streets, out in lying county areas where the CHP always is not. So it's always good to have those extra eyes to curtail this criminal activity. We're urging your aye support, and I'm here to answer any questions that you might have.
Thank you. If you could please stay seated, Lieutenant.
Yes.
We're going to hear from the opposition, but I may have a question for you after that. So if there is any other support, any opposition? Cal, can you quiet your phone? Welcome.
Thank you very much. My name is Catherine Brandenburg, and I'm with the Flanagan Law Firm, and we represent the Institute of Scrap Recycling Industries. We're opposed to this bill for a number of reasons. First, last year this committee and the legislature passed out a number of bills pertaining to metal theft. And we worked diligently with law enforcement that created a program or a record-keeping system when someone who goes to a recycling facility to recycle metal will take identification, a photo ID, a thumbprint, copies, photograph of the material. we worked extensively with law enforcement to help curtail theft. And I have noticed in the last year we haven't been receiving as many reports as we were, the previous 3-4 years. We're opposed to this bill because, even though the Assemblywoman did state that the law enforcement just will not pull over anyone, it doesn't specifically state that in law. And if someone like yourself is carrying aluminum cans, is carrying any type of scrap metal in their vehicle, they could be pulled over and without cause. And so we have a tremendous concern over that. I mean, we're looking more at low-income people who are going to homes and being asked by the homeowner to take junk from their home to recycle it or to take it to a landfill. So someone like that could be pulled over easily. You or I could be pulled over with carrying any type of metal. The other issue we have is that this language is put into statute that really deals with organic materials. It really should not be in this particular code section. This is designed more for industrial haulers, commercial haulers, not for the mom and pop businesses who do not have manifests, things like that, when they're hauling material. And so we ask for your opposition.
Very good.
Thank you.
Thank you. Anyone else who'd like to speak in opposition? Did we get a vote? Ms. Carter, I know you're dealing with a very real issue, and I don't take it lightly. I personally do have serious concerns without cause. I can imagine any number of situations where someone may be a recycler and quite innocent in using a public road, and without cause could be stopped. And I don't believe that is in fact constitutional, but would give me pause even if a court were to rule it constitutional. The analysis makes reference to the United States Supreme Court discussing the right of people to be secure in their persons, houses, this is the court's wording, papers and effects against unreasonable searches and seizures, and that an automobile stop is subject to the constitutional imperative that is not unreasonable under the circumstances. I know it's always dangerous to ask a question to someone when you don't know the answer, but, Lieutenant, I'm going to give it a try anyway. Current law, which the Assemblywoman is trying to change, to expand the Highway Patrol's ability to make these stops to sheriff and police. I would imagine that if a police officer or a sheriff had some good reason enough to be suspicious that someone he or she just saw drive by was involved in this nefarious activity that's causing, in particular, the Central Valley so very much trouble. Is it really that difficult for that officer under current law to pull that driver over and saying, I saw you weaving just slightly, or, you were going 4 miles over the speed limit? I can't imagine it's impossible, if not difficult, to pull someone over currently without having to go down this path, which I believe really does challenge the Fourth Amendment.
That's true.
That's a good answer.
However, we could follow someone for miles and miles and never have any reason to pull them over other than a suspicion that the metal theft or metal alloy theft or metal products that they're hauling might be stolen. The thieves are taking metal from the utility companies. This is, not just old junky metal, but it's brand new spools of copper tubing, any other kind of wiring. They're taking it from construction sites. They're ripping off the air conditioning wiring from air conditioners at schools. So we're not focusing on the little quote-unquote mom-and-pop operations or someone who's cleaning up somebody's property for them.
Right, and you don't have to clarify for me the problem. I stated from the outset, I get the seriousness of the problem.
We could follow someone for miles and never have any reason to stop them for a moving violation.
See, I think, well, I recognize you have more experience than I, but I just can't imagine that an officer currently wouldn't have the wherewithal. You know, so I've been trying to think creatively, how could I offer some suggestion that you could move this bill forward at this time? The analysis also points out to sobriety checkpoints. Now, those are random and without cause, but they're legal and they can withstand the Fourth Amendment. The difference being, of course, that they stop everybody. It's not that someone is picked out, and that makes it constitutional. So I wondered if we could potentially do this through a checkpoint where everyone would be stopped in an area, and maybe even to tie it to a County Board of Supervisors having to pass a local ordinance that would allow for that, because there's a significant problem in that particular county. But our consultants are telling me that doesn't rise to the level of the danger of driving and alcohol, and also the nexus between alcohol and driving, where driving with metal is not the same kind of nexus. So I just share all this with you to let you know I have been thinking about this. I do want to deal with the problem that you're trying to address. I can't come up with the answer today. So my suggestion is that we make this a 2-year bill, that we continue to work on it and see what we can come up with.
With all due respect, Mr. Chair, I, of all people, worry about being stopped by a police officer. This particular crime is fairly new, and it doesn't preclude any other laws or any other stops or any other thing that has happened in the past and that is currently going on. In my county, in San Bernardino County, it is really, really causing havoc. And, you know, property owners, schools, all of these people are just really having a problem. These officers are going to be trained to spot these kinds of products specifically, just like the CHP. And the CHP just cannot do it all. San Bernardino County sprawls, and we really do need this help. And this particular issue was not as big several years ago, but it is now, and I think it will continue. And this is a good measure, and it will address the problem not just in San Bernardino County, but all over the state. And I think it's a new issue that you really need to consider and, you know, allow this bill to go forward.
I recognize the seriousness of the issue. It's not new to this committee. We've been dealing with the issue of metal theft for a number of years now since I've been chairing public safety. Senator Cedillo, I think, has a comment or a question.
Well, I have just two concerns. One, obviously, I mean, this is a problem. And I think we wrote legislation last year with Assemblymember Barry Hill that was designed to address this. And so the problem is not just a California problem, but it's a national problem. I believe it stems from challenges in our economy.
Right.
And so it affects, it's always surprising to think of the creative ways that people will come up. No lights at the Little League. You know, you show up for your game and whoops, well, they took the copper, they took the metal, you know. Urns from a cemetery. I mean, who has the audacity to do that, et cetera, et cetera. So the problem is well documented. But at this point, I don't know that with respect to legislation that we've passed to address this, that we know that has not been effective, that we've had an opportunity to review or evaluate it yet. But I do have a concern, and you know my concern. I've talked to you about this before. We have 2.5 million motorists in California who cannot drive with a license. 2.5 million motorists, many of them in San Bernardino County. If they get stopped for this, and an officer finds, well, they were moving stuff with permission, they were hauling stuff out of an effort to raise revenue, they were involved in some charitable activity to take stuff to a recycling center. But now he finds somebody who doesn't have a license, which means immediately then that person will be left on the highway and their car towed. Now that's an unintended consequence of the expansion of this effort, and I'm not prepared at this moment, when we have 10% of our motorists who can't drive legally, to enhance the possibility that they're going to be stopped simply for driving with metal. And I think that's an unintended consequence. but one nonetheless that I'm not prepared to promote.
Thank you, Senator Cedillo. It's a much stronger and compelling argument than my concern for Fourth Amendment. It has real-life effects, so I thank you for pointing that out. And I also just want to underscore that there were 5, Senator Maldonado, Senator Calderon, Assemblyman Berryhill, Assemblywoman Ma, and Assemblyman Adams, all with chaptered statutes on this subject just in 2008. So we have been...
you see that it's a problem.
It's a real problem, but as Senator Cedillo pointed out, before we go down this path, if we were to ever, I think it's wise for us to give a little time to these most recently chaptered statutes to see how impactful they are, and maybe these 5 will take care of the problem significantly over the next couple of years. But this unintended consequence of people being stopped for driving with metal when they are driving with purpose and cause, not illegally, their crime is that the state of California doesn't allow them the process to be trained, tested, and insured just because of where they were born. So, again, my suggestion, you certainly can take it or leave it, rather than take a vote today, though you may have the votes, I don't want to presuppose you don't, that we continue to work together, because I'm earnest in wanting to see if we can't find some solution and amend the bill over a 2-year period.
Well, thank you so much, Mr. Chair, and I will take your suggestion.
Okay.
Senator Leno?
Yes.
May I
Lieutenant.
state something for the record?
Of course, please.
The bill that we're proposing to amend, Vehicle Code Section 2810, I just wanted to let you know it has been on the books since the early 90s.
Okay. Thank you, Lieutenant. Any other comments?
Well, I just, you had also made comment with respect to the DUI stops, and that's what's brought my attention. I myself personally was stopped in the city of Pomona. These checkpoints are being abused. I support, obviously, removing drunk drivers from the highway, and I think they're appropriate at appropriate times. But there are cities that abuse this by having them at 10 o'clock Saturday morning, run them through the afternoon, run them through boulevards where they know it's likely undocumented motorists live, shopping centers, Home Depots, etc., and then literally take thousands and thousands, no exaggeration, of vehicles from families and create a whole industry that then subsidizes small cities throughout California. There's been an abuse of this. We've been fighting it. The courts have ruled on it. But this is one example of how a well-intentioned bill becomes utilized for politics as a way of abusing the residents of California.
Very good point. And not to concern you unnecessarily, our legal counsel is telling me that because there's not the nexus between driving and metal, that we couldn't do that anyway. So, but unintended consequences everywhere we look.
Thank you.
All right. Well, thank you, Assemblywoman, for working with us, and we'll continue our efforts and see where we can go.
Thank you, Mr. Chair. And may I ask the status of AB 114? It was supposed to be on the agenda today for a vote-only consideration.
That will be next week.
That will be next week. Thank you, sir.
All right.
Thank you.
Thank you. Next. Senator Bell, I see you're next, but before you get up, I'm going to ask, since Assemblyman Cook has been sitting here for quite a while, and I don't believe this bill is going to take that much time, we could take him next, and then you will follow. Assemblyman Cook. This is item 9, AB 589, Department of Corrections and Rehabilitation contracts.
Thank you, Mr. Chair. AB 589 allows the California Department of Corrections and Rehabilitation or local law enforcement to contract with county veteran service officers to provide assistance to incarcerated veterans and their dependents in presenting or pursuing any claims to state and federal benefits. At the request of the Assembly Appropriations Committee, amendments were taken to restrict these contracts to 6 correctional facilities and cap them at $20,000 annually. The goal of this bill is to tap into federal money, which these people have already earned by virtue of their military service. and even more important, to help reduce recidivism by providing an economic stability to inmates and their families. It would also relieve some of the stress on state-funded programs such as Medi-Cal. Now, the reason I'm perhaps somewhat passionate about this is obviously I'm a veteran. And when you come up here, there's certain areas that I think you have a little bit of expertise. And veterans that have this benefit where you could apply it to a support system, particularly their families and their economic. Here you actually have a chance to do something to reduce the recidivism rate. And I actually believe that talking county service officers, veteran to veteran, as opposed to, maybe the Department of Corrections, because they know the benefits. They talk the same language. They are sympathetic and empathetic to some of their problems. And if I, in 6 years can do one thing, perhaps move the dial and reduce the recidivism rate 1%, it doesn't sound like much. But God, the way we're going. And if I can do it for like 5 or 10% for veterans that are incarcerated, is somebody come up to you on the street and say, Cook, what have you done in 6 years? I can say, hey, you might not think this is important, but families like this, they have been given a second chance to do this, and we've kept them from going back into this terrible prison system again. So I have my witnesses here with me.
Thank you for your passion.
Thank you.
All right. Those in support, we're just going to do 2 each, both sides, and then we'll
Mr. Chairman, members, Pete Conity representing this sponsor, the California Association of County Veteran Service Officers. I guess the short version would be things are not as rosy out there as corrections and the federal VA would have you believe from the analysis. Right now, if corrections could already do this, why haven't they done it? Well, it doesn't save them any money, but it saves the state money if we can reduce recidivism. VA does, I think, the federal VA has 2 people in the entire state of California whose job it is to visit prisons. So they do not get to them as often as they would have you believe. I also have some passion on this issue as a Vietnam veteran, and I also represent the American Legion and the Vietnam Veterans of America. And many Vietnam veterans ended up in prison after the Vietnam War because nobody knew what PTSD was. Some of those people are still in prison. But the reason for this bill is because county veteran service officers are government employees who can cut through the red tape. They are accredited by the State Department of Veterans Affairs, and they are accredited by the federal VA. And they can get to the VA records quicker than anybody else can. They are trained. Many of them have 30 years of service. So by being government employees, they can cut through the red tape. Right now in the state, there is one volunteer program that is overseen by a county veteran service officer, and that is at Soledad.
Mr. Conity, I don't think we have any opposition, so if you could conclude.
I asked for yes, sir. Got it.
Thank you.
You're welcome.
Others in support?
David Warren, Taxpayers for Improving Public Safety. As a chaplain inside the state prisons, I too often see veterans suffering from PTSD and substance abuse was associated with it, which is why they're incarcerated. And when they parole, they have no support net because of the lack of transition. This bill would assure that transition, and my only regret is that the Appropriations Committee limited it to so few facilities because we have so many veterans who are in fact in need. Thank you.
Thank you, Mr. Warren. Others in support, identification, please.
Liberty Sanchez on behalf of the California Public Defenders Association in support of this measure.
Mr. Sanchez.
Craig Brown, CCPOA, in support.
Thank you, Mr. Brown. Anyone else in support of Assemblyman Cook's bill? Any opposition? Please join us.
Hi, I'm Karen Shane from Legal Services for Prisoners with Children, and we had been in very strong support of this bill, and we're certainly in support of the thinking and the work that has gone into it. Our problem with it is with the amendment, with the limit of this bill to only 6 prisons. I don't understand exactly why the Assembly would have chosen to do that, because, in fact, I don't think that it costs any more to allow other prisons to do it. We're not requiring other prisons to do it. And so, regretfully, with that amendment, we're not able to support the bill in the way that we had before.
Very good. Thank you, Ms. Shane. Anyone else wish to speak on the bill? We have any comments, questions from the committee? Mr. Conde answered my question, but if you could, in your close, real briefly, Mr. Cook, given that there's nothing that prevents the state from doing this now, I understand that we are understaffed and probably just not enough attention to it. If that's probably the reason why you're moving forward nonetheless.
That's exactly the reason, and obviously we don't think the attention has been given. Just briefly, I wanted to, I'm not crazy about the amendment either, but that's how we got out of appropriations. We hope that if this bill goes forward, we can collect the data from this, and if it moves the dial, I think we can make the argument that you're not costing the state money. In the long run, this is a tremendous cost saver. So that's why, we want to get it through, we want to collect it, and hopefully we'll be back here again expanding this. So that's for your aye vote.
No, we wouldn't mess with that. It's disrespectful. So thank you, Mr. Cook. We do have an amendment by Senator Cedillo, and we will call the roll. Thank you for your advocacy on behalf of our veterans.
Thank you very much.
Leno?
Aye.
Leno, aye. Benoit? Cedillo? Aye. Cedillo, aye. Hancock? Huff? Steinberg? Wright? Aye. Wright, aye.
Thank you, Assemblyman. As you know, we're missing some members, so we'll put the bill on call.
Thank you very much.
All right. Thank you.
No, I know.
We'll take Mr. Bell and then Mr. Amiano. So Mr. Bell's bill is item number 7, AB 438, Persons with Developmental Disabilities. Welcome, Assemblyman.
Thank you, Mr. Chairman, members. This is AB 438. People with cognitive developmental disabilities who get involved in the criminal justice system are at a distinct disadvantage whether or not they actually commit a crime. AB 438 gives the courts discretion, but does not require courts to order more appropriate services and supports for people with cognitive developmental disabilities who are charged with nonviolent felonies. AB 438 also requires the Department of Developmental Services to convene a task force to identify strategies and best practices for our local and state interagency coordination and cooperation in addressing the needs of adults and juveniles with developmental disabilities in the criminal and juvenile justice systems. And I ask for your aye vote on that.
Thank you, Mr. Bell. We're going to ask for 2 witnesses in support and opposition, and then others just to identify. So if you want to identify which 2, please proceed.
Brandon Tartaglio, Disability Rights California, in support of the bill. AB 438 is a positive measure that is beneficial to the criminal justice system, the public, and individuals with cognitive developmental disabilities. It'll help them get the supports and rehabilitation that they need. So we support the bill.
Thank you, Mr.
Glenn Backus, Drug Policy Alliance, in support.
Thank you, Mr. Backus.
Liberty Sanchez on behalf of the California Public Defenders Association. There are approximately 16,000 developmentally disabled defendants in the criminal justice system. This bill will provide immeasurable assistance in ensuring that they're better served and taxpayer dollars are saved in more appropriately serving them. So for those reasons, we're in support.
Good points, Ms. Sanchez. Thank you.
Jim Lindberg, Friends Committee on Legislation of California, in support.
Thank you, Mr. Lindberg.
Karen Shane, Legal Services for Prisoners with Children. I'm also representing All of Us or None and California Coalition for Women Prisoners, and we're all in support.
Thank you, Ms. Shane.
David Warren, Taxpayers for Improving Public Safety, in support.
Thank you, Mr. Warren. So just to clarify, among the other things, I think the core of it is that irrespective of whether an offender was a regional center client at the time of the charged offenses, that there would be eligibility.
Yes, and that's in light of our current situation. A lot of people with developmental disabilities are unfortunately not regional center clients, and they should be eligible for these kinds of programs as well. Thank you.
Great. Thank you for just confirming that, Mr. Bell, and we want to allow for oppositional voice.
Mr. Chair and members, good morning. Corey Salzillo on behalf of the California District Attorneys Association. We're opposed to the bill, unfortunately. The biggest issues is the expansion of this existing program that we have concerns with. We generally don't support the expansion or creation of pre-plea diversion programs. In other words, diversion programs that do not require the person to plead guilty to the offense prior to entering the diversion and giving the person either further incentive to comply with the terms of the diversion. Because if a person in a post-plea diversion messes up or they don't complete the program, there's a guilty plea, the person's sentenced, they go through the system. There's no such requirement in this existing program. The bill would not add such a requirement. The program, as it exists and as it would exist after the implementation of this bill, does not require that the cognitive developmental disability be the cause of the offense or even a contributing factor to the offense. That may come up presumably in the reports that are required to be filed pursuant to the existing program. There's no requirement in the statute. And finally, while a person who has a violent or serious felony charge under the current situation, there's nothing that precludes a person with a history of violent or serious crimes, violent or serious felonies from participating. Thank you.
Thank you, sir. Any other oppositional voices? Senator Wright, you have a question. We'll take that as a motion. Thank you. Any other individuals wish to testify or questions from the committee? We do have a motion. We'll call, if you'd like to close, we'll call the roll. Go ahead.
Call the roll.
Thank you.
Like the rolls.
Leno?
Aye.
Leno, aye. Benoit? Cedillo? Cedillo, aye. Hancock? Huff? Steinberg? Wright? Wright, aye.
We'll put the bill on call. As you know, we're missing a few members. Thank you, Assemblyman Bell. Assemblyman Amiano, welcome to our committee. You have AB 382, which is our item number 6.
Thank you. Chair Leno, Mr. Chair and Senators, I present to you AB 382, a measure to amend the Sexual Abuse in Detention Elimination Act. I'd like to thank the committee and staff for all their work with my staff on amendments. My bill would add sexual orientation and gender identity to the current list of factors that should be considered when classifying and housing prisoners. One of the most important tools available to corrections officials to prevent sexual assault and the use of appropriate prisoner classification and housing protocols. While anyone can be a victim of sexual violence in prison, typical victims are young, nonviolent, or first-time offenders. Lesbian, gay, bisexual, and transgender prisoners, or those perceived to be LGBT, are also exceptionally vulnerable to violence. Sexual violence against prisoners who are LGBT is a recurring problem that needs to be addressed. According to a recent study of the California Department of Corrections and Rehabilitation, 67% of LGBT inmates report being sexually assaulted by another inmate, a rate 15% higher than all of the overall populations. Our prisons have been the focus of recent attention and litigation involving overcrowding and violence. Recognizing these problems, the legislature enacted a law in 2005 to require CDCR to consider certain risk factors that lead to inmates becoming targets of sexual victimization, including age, whether the inmate is a violent or nonviolent offender, whether the inmate has served a prior term, and whether the inmate has a history of mental illness. Unfortunately, existing law does not provide specific protections for LGBT inmates housed by CDCR. My bill would simply add this, sexual orientation and gender identity, to a list of criteria that the CDCR must consider when classifying and housing prisoners. The bill is sponsored by Equality California, supported by Taxpayers for Improving Public Safety, Asian Communities for Reproductive Justice, California Communities, United Institute, API Wellness Center, All of Us or None, TGI Justice Project, and the California Coalition for Women Prisoners. With me today, I have Alice Kessler with Equality California and Lori Sexton, researcher from UC Irvine.
Thank you, Assemblyman Amiano, for building such a strong coalition and for your not insignificant bipartisan support in the Assembly on your bill.
Thank you.
Ms. Kessler.
Thank you. Good morning, Mr. Chairman and members. Alice Kessler with Equality California. We're the sponsor. Would like to note that this legislation was prompted by an informational meeting chaired by Senator Romero last year that brought to light the epidemic of violence against LGBT prisoners. This is especially a problem for transgender women who are housed in men's prisons. It's not hard to understand how a person who displays feminine characteristics and mannerisms could be singled out for violence in a men's facility. And the statistics of abuse against this particular population are staggering. You'll hear about that in a moment from our other main witness. I'd just like to read a short excerpt from an anonymous transgender prisoner who cannot personally be here today, but had the courage to come forward with her story. She says she arrived at Folsom State Prison in January of 2006. At first, I was housed with an older gentleman that was respectful toward me, but then I was transferred to a different cell with an inmate who turned out to be verbally and sexually abusive. Shortly thereafter, I was transferred again. My new cellmate was kind to me in the beginning, but within a week, he had completely switched. He was incredibly violent, and he raped me regularly. He controlled my every move. He decided when I could eat, so I usually didn't get to eat. I had my own stash of chips and other food from the commissary that I tried to eat at night when he was asleep, but I was too afraid to even open a bag of chips because the sound would wake him up. And I knew that if I woke him up, I would be beaten and raped. This went on for about a month. Members, no person should suffer these kinds of indignities, and this bill would encourage a proactive rather than a reactive approach, and would simply urge your aye vote.
Thank you, Ms. Kessler.
Morning, Mr. Chairman, members. My name is Laurie Sexton. I'm a researcher at the University of California, Irvine. I'm here today in support of AB 382 to present findings from 2 social science research studies of transgender inmates in California. Both studies were conducted by Professor Valerie Jenis of UC Irvine and funded by the CDCR. Let me begin with the first study. The aim of this study was to explore the contours of sexual assault amongst inmates in California prisons. The research team gathered self-report data through face-to-face interviews in 6 California prisons. 2 samples of inmates were interviewed, a random sample of 322 male inmates and a smaller purposive sample of 29 transgender inmates. Of the male inmates interviewed, 4% reported being sexually assaulted while in a California correctional facility. In contrast, the figure for transgender inmates is a staggering 59%. What this boils down to is a rate of sexual assault for transgender inmates that is 13 times higher than for male inmates. These findings and a host of others were presented to the CDCR in a full report in April of 2007. In order to more fully understand the results in this report, the CDCR requested a follow-up study focused solely on transgender inmates. Rather than interviewing a small sample of transgender inmates, for this study we worked with the CDCR to identify all transgender inmates in all California prisons. The findings from this study highlight, reinforce, and elaborate upon those from the earlier study. Again, we found that transgender inmates are disproportionately victimized in prison. 58.5% of transgender inmates reported sexual assault during their incarceration history, a figure remarkably similar to the number obtained in the first study. When expanding this definition to include sexual misconduct, the number grows to 69.4%. For both measures, transgender inmates reported higher rates of victimization inside California correctional facilities as compared to outside on the streets. Clearly, the results of these 2 studies show the extent to which transgender inmates are in a situation that is precarious at best. Victimized in prison more than they were on the outside, and victimized far more than their male counterparts, it is the responsibility of the CDCR, in accordance with the Federal Prison Rape Elimination Act and the California Sexual Abuse in Detention Elimination Act, to take every step possible to ensure the safety of this population. This bill is a step in the right direction towards helping the CDCR achieve this goal. Thank you for your time.
Thank you very much for your research and for your testimony. So others in support, name and identification, please.
David Warren, Taxpayers for Improving Public Safety and Support.
Thank you, Mr. Warren.
Glenn Backus for Ella Baker Center for Human Rights and for Drug Policy Alliance in support.
Thank you, Mr. Backus.
Karen Shane, Legal Services for Prisoners with Children, All of Us or None, and California Coalition for Women Prisoners in strong support, and we really want to thank Mr. Amiano for doing this bill.
Thank you, Ms. Shane.
Liberty Sanchez on behalf of the California Public Defenders Association in support.
Thank you, Ms. Sanchez. Anyone else in support?
Jim Lindberg, Friends Committee on Legislation of California, strong support.
Thank you, Mr. Lindberg. Or in opposition? I don't think there is any. Do we have questions or comments from the committee? We have a motion by Senator Cedillo. If you'd like to close, Mr. Amiano.
I strongly encourage, and I vote, and I thank all the witnesses.
Thank you. It's a very important issue, and I thank you for bringing it forward.
Thank you.
Okay, we'll call the roll.
Leno?
Aye.
Leno, aye. Benoit? Cedillo?
Aye.
Cedillo, aye. Hancock? Huff? Huff, no. Steinberg? Wright?
We will place the bill on call.
Thank you, sir.
And move it later in the meeting. Thank you, Mr. Amiano. Our next author is Mr. Huffman. Our item 11, AB 708, Fish and Wildlife Poaching. Welcome,
Good
Assemblyman.
morning, Mr. Chair. Good to be with you today. Mr. Chair, this bill addresses a growing problem for the state of California. In fact, not since the early 1900s have we seen the levels of poaching that we're experiencing in recent years. Between 2005 and 2007, unlawful wildlife poaching is believed to have increased by 25%. And this is because even as the economy has declined, the incentive for poaching has grown. People can make a lot more money, quite simply, breaking the law and poaching and participating in the black market for the sale of these species, even if they get caught, because the penalties are a slap on the wrist. And so we've designed a system, a very lucrative system, that incentivizes people to break the law and tells them that it pays to poach. The maximum fines are very small. They're only $1,000 or $2,000. There are no minimum fines for serious poaching violations. The chances of getting caught are extremely low because California has the fewest wardens per capita of any state in the nation, and as we know, the warden crew is only going to be strained further this year and in the years to come. And local prosecutors, frankly, have too many other demands on their departments to fully prosecute the cases that wardens do bring forward. So AB 708 will make some changes that will address this situation in some very important ways. Specifically, it establishes minimum fines of $5,000 for the first offense, $10,000 for the second offense. It directs that these fines at illegal commercialization, and also to persons who possess over 3 times the allowable fishing or hunting limit. And it allows Fish and Game to permanently revoke the license of a person convicted of one of these violations. And that's important because we're finding that many of these serial poachers, folks who go out, break the law, make money breaking the law, get the slap on the wrist, get their license back a year later and get right back in line. And in some cases, I think you'll hear from some of the witnesses, has literally been passed down generation to generation within families. So we have to begin to get at that, and I think a lifetime revocation of hunting and fishing licenses is a good part of that strategy. This bill also allows a judge, upon conviction, to order the forfeiture of assets associated with the crime. And I know that's an issue that the committee has flagged with some concerns. I do want to clarify that judges don't have to use the forfeiture tool. They have discretion to consider various factors in assessing whether or not it's an appropriate remedy. But I believe you'll hear from some of the witnesses here today that they think forfeiture is a critically important tool to have in the toolbox, and we'd like to work with the committee to continue to have that tool available. And then finally, the bill increases the incentives for local prosecutors to actually pursue these violations by directing that some of the penalty revenue will cover their costs of prosecution. This is a bill that's certainly not aimed at law-abiding hunters and fishermen. In fact, we have broad support from hunting and fishing interests, as well as environmental groups, law enforcement groups. There is no opposition to this bill, and I respectfully request your aye vote. And with me, I have several witnesses that I hope we can hear from.
Thank you, Mr. Huffman. Those in support of the bill, we're allowing 2 speakers from each side and then name and identification.
Senator Leno and members of the committee, I'm Dan Taylor, Policy Director for Audubon, California. We're pleased to be working with Mr. Huffman on this important matter. Poaching represents both a crime against nature and the theft of important resources that are held in the public trust. We thank Mr. Huffman for his leadership, and we're proud to be a part of a broad effort, as he mentioned. Frankly, what's happening is that the pace of the crimes being committed against wildlife are outpacing our ability to enforce and to bring these crimes to justice. Better law enforcement and stronger deterrence is absolutely necessary. And many believe that poaching may have been a crime that has existed years and years ago. Very much that is not the case. It's a crime that is with us today, and it deserves a very, very strong response to protect nature. And we ask for your aye vote. Thank you.
Thank you, Mr. Taylor.
Mr. Chair, I misspoke a moment ago. We did get late opposition from ACLU, so I did not want to misrepresent the record.
Thank you.
Good afternoon. My name is Lenore Anderson. I'm here on behalf of San Francisco District Attorney Kamala Harris. The District Attorney's Office supports this bill for 3 reasons. First and most importantly, we think it's very important to preserve the natural resources of the state. This is important to all Californians that we take aggressive action to halt practices like poaching. Second, in San Francisco, we see the market-side impact of poaching. What's stolen from the rural areas is often brought to the cities for selling. There's an underground market for buying and selling poached abalone and other wildlife. These illegal business deals not only hurt the environment, they also harm environmentally friendly businesses and businesses that are not attempting to support poached wildlife and to make money off of it. So poaching is both bad for the environment and the economy. And the third reason we support it is because we need stronger penalties in order to deter the action. Poaching is certainly on the rise, and so we need to make the consequences real. Thank you.
Thank you, Ms. Anderson. Give our best to the District Attorney, please.
I will.
Thank you.
Good morning, Mr. Chair, members. Jason Ryan, California Under Heritage Alliance. Our organization represents 35 wildlife conservation and hunting organizations, and we're fully in support of this measure, particularly the forfeiture section of the bill. Very important. We need the deterrent. Thank you.
Thank you, Mr. Ryan. Others in support?
Matt Robinson with the Department of Fish and Game. With me today is Nancy Foley, our chief of our enforcement division. We are neutral on the bill, but are here to provide any technical assistance and answer any questions you guys might have.
Thank you, Mr. Robinson. Anyone else in support?
Hi, I'm Barbara Schmitz. I'm here on behalf of the California Animal Association and our more than 1.5 million California members. We're in support.
Thank you, Ms. Schmitz.
Michael Endicott with Sierra Club California. We're also in strong support of the bill. Thank you.
Thank you, Mr. Endicott.
Mr. Chairman, members, Dan Phillips out on behalf of the Los Angeles District Attorney's Office in support.
Thank you, sir.
Chairman Todd Tognazini, Fish and Game Wardens Association, one of those individuals assigned to thwart poaching and understand the increase in poaching, lack of staffing that we have, the furlough issues and all the other budgetary crises, and how critical it is for California state wildlife to now be worth a little bit more value. And we see it every day in court when we go to court, how it's really difficult to put a price tag on wildlife. And it's really critical that we start realizing that it's worth a whole lot more.
Thank you, sir. You bet.
Jerry Carno, Fish and Game Warden Association, Legislative Liaison. Between President Todd Tognazini and myself, it's about 50 years of law enforcement experience, and it's very frustrating for the wardens that put their life on the line to protect the natural resources with armed criminals, wildlife that belongs to, and natural resources that belong to all people of the state of California. And we strongly support this bill to have that in our tool chest to protect our natural resources. Thank you.
Thank you, Mr. Carno. Anybody else in support? Quite a bit of support. Anyone in opposition, please step forward.
Mr. Chairman and members, Francisco Lobac on behalf of the American Civil Liberties Union. One against a lot. But
I think you're up to the task, Mr. Lobac.
As usual, I'm up here by myself. Our concern is one of proportionality, and we've talked to the author's office and to the committee in terms of the expansion of the asset forfeiture provision. The committee's been very careful in terms of situations on which you expand asset forfeiture laws. Generally speaking, it's for particularly serious crimes. This sort of general issue came before the committee, I think last year, the year before, and so it was narrowed down to specific species. The way this bill is drafted, essentially it would permit the forfeiture of vessels or cars for any violation of the Fish and Game Code that's done for personal gain, as is indicated, because this is for commercial purposes, but commercial purposes is defined as profit or personal gain. I would assume that means taking a otherwise, not overfished species or over-hunted species, and I don't know what that means, selling it to your friend or in this situation, you would lose your boat. Or 3 times the bag limit. I'm no expert on fish and game law. My understanding from a few years ago that you could have a bag limit, a relatively small amount of fish, otherwise not overfished fish, and you have 3 times that amount and you don't sell it, you just keep put it in your freezer, you could lose your vessel. Now, I appreciate the reality of the environmental situation and the like, but we have tried to be somewhat proportional in terms of the use of asset forfeiture statutes. In the other areas, it's certain amounts or prior convictions or the like. And that leaves aside, as your committee analysis point out, I don't know how much the forfeiture is going to care when your first offense for any of these crimes are going to be a fine of $18,500 perhaps. The fine will take care of the vessel or the car. So our concern is if you're going to expand the asset forfeiture statute, you have to be a little more specific and a little more protective of the proportionality issues.
Thank you, Mr. Lovaco. So I think the issue of proportionality is of concern. Certainly it's to me, and this is not the first bill that's come through this committee with regard to forfeiture. So in your own opinion, how would you feel about a second or a third offense with regard to the
We've done that. This is what the committee has done, for example, on other type of environmental statutes like the dumping statute in terms of illegal dumping in the communities. You have created an ability to engage in a forfeiture, but essentially you have an initial conviction, which you could do an impoundment, which is what you've done in other statutes, and if you do it a second time, you're convicted a second time, then you go through the appropriate asset forfeiture process. So that's an alternative than other ways. The Fish and Game Code does permit for forfeiture. How many seashells by the seashore? But I think the effort was to try to limit it to not just protected species, but sort of overfished and overhunted species. I understand that they don't have enough people to go after folks out in the community who do bad things, but there's got to be some limitation, I think.
Very good. Thank you, Mr. Lovaco. Mr. Hoffman.
Mr. Chair, I would like, with your indulgence, to ask Fish and Game their thoughts about that. We've certainly come up with one idea that we think might address some of the concerns. We think that personal gain may be a little too broad, and we could strike that and just have for-profit be the factor that triggers forfeiture. But as to whether we can tease out certain species that merit forfeiture versus others, I think I would like to hear from Ms. Foley at the department.
Actually, I'd rather, since we've got some limited time, to maybe focus on the necessity for a first offense, because I don't know that this committee is going to get that. That's not our expertise.
Right.
Which species, which not. But
and
first
on the
offense,
first offense, that certainly is a factor that a judge could consider, because a judge has broad discretion on whether or not to use the forfeiture tool in the first place. First offense would be an obvious factor that a judge would consider. We can certainly make that explicit, working with the committee, as a factor that must be or can be considered. But the reality is, it's a game of catch me if you can out there with these professional poachers.
I am well aware of that.
And so I think there may well be situations involving a first offense. Again, I would invite the department to weigh in on this that are so severe that they would merit the most extreme remedy.
Very good. If you'd like to comment.
Well, there were many questions that were posed during that, but
for the record, if you could introduce yourself.
Yes, Nancy Foley, Chief of the Law Enforcement Division of California Department of Fish and Game.
Welcome.
Thank you. As Senator Benoit said, he caught many drunk drivers that said it was their first time, and he hesitated to believe that it was the first time that they ever were drinking and driving. It's the same thing with poaching. The only difference is that there are 7,500 highway patrol officers. There are 203 game wardens in the state of California today. and we have 159,000 square miles to patrol. We have 1,100 miles of coastline. We patrol out to 200 miles to sea. The chances of us catching somebody once is somewhere between 1% and 5%. The chances of us catching somebody twice, get raised even further. So we really need the tools to be able to prosecute those people on a first-time offense and make it not worth their while to go for a second time.
Thank you, Chief Foley. We appreciate your comments and experience that you bring to the committee. Yes, Senator Huff.
Yeah, I'd just like to underscore that testimony in that a couple of years ago I was fishing the Lower Sac in Reading, fly fishing, drift fishing, and there was somebody in another boat, motorized boat, with a casting net. And this is during the salmon run, and the trout is what we were fishing for. Nevertheless, he was a casting net out there. We got on the phone immediately, called Fish and Game. We were out there about another 4 hours and see nobody from Fish and Game, because it is such a Wild West out there. And this is a populated area. Most areas that are doing poaching are not populated like this, but it just underscores the paucity of enforcement. And so there does come a point where you have to have the penalty that is egregious so that they have to think twice about doing something like this. So I fully support the bill.
Thank you, Senator.
Assemblyman Huffman, having sat on the Budget Conference Committee, I'm aware all too clearly of how underfunded the department is. And I think Senator Huff has described the situation accurately. It is a Wild West situation, and that many poachers are operating under the impression that they have complete immunity, and it's very unlikely that they are going to get caught. I think that the increase in fines currently in your bill are significant, and another way to state it is they are not insignificant. But I do have a concern that the punishment may not fit the crime when possibility someone's boat is going to be taken because on a first offense they happen to be caught. So the 3 times the bag limit, if you want to speak in defense of that. Otherwise, I would direct the committee's attention to page 8 of the bill, line 17, which is subsection D, with regard to the forfeiture, any offense that involves a violation of section 12012 or 12013, that we might say any offense that involves a repeat violation relative to forfeiture.
Senator Leno, if I understand you correctly, that would mean even for commercialization poaching, there would need to be a repeat offense before the tools of the trade that we think have probably been acquired through ill-gotten gain in poaching would ever be subject to forfeiture? The 3 times. The first part of your question was about 3 times the bag limit, and I understand that may raise some red flags that are different than commercialization.
So section 12012 that's the commercial, but 013
is 3 times.
So we would, my previous comments notwithstanding, that we would not use the repeat violation for 012, but just for 013.
So just for the 3 times the bag limit. Would you be willing to work with me on some factors that might make forfeiture available in a 3 times bag limit case that warranted forfeiture?
Give me a try.
I mean, for example, there's been discussion here about certain types of species that are of special concern. There's been discussion about other evidence that may be present that shows that this was in all likelihood not the first offense. It was just the first time getting caught. I guess what I'm saying is I'd like to reserve the possibility in egregious cases of forfeiture, again, because taking that vessel, taking that vehicle that's used in the crime is probably one of the most effective ways to address it.
Again, I think that the size of the fines are not insignificant, so I think there is real deterrent there. Without getting into the naming of species, which again I don't think is this committee's expertise, but with regard to species that are at great risk. So we would take in a category. Would that be
Threatened and endangered would be
exactly
probably under the state or federal statutes would be one measure. Yeah.
So if you can give us just a moment, we're going to have a look at the bill.
Think 3 times the bag limit for a bald eagle. There is no bag limit. Maybe a better example from the sponsor. Yeah.
Senator Leno, if I may, the 3 times section that you guys are referring to,
yes.
It really wouldn't be appropriate to list out, say, threatened or endangered species, because those you can't even hunt or fish anyways, point. So that'd be kind of relevant.
Yeah, that's right. Yeah.
So that sort of makes the point that they're not at risk, so the second offense or repeat offense would be of lesser concern. And then also just pointing out that we're talking about fines of 5 and 6 figures when we're talking about assessments added. These are very steep already.
Mr. Chairman, if I may make a suggestion.
Sure.
In the past, the committee has also permitted forfeiture for the profits from the crime. So to the extent that the statute needs to be tweaked to say that if you bought the boat or you bought the vessel or you bought the accoutrements from the profits of your illegal activity, then those kind of forfeiture provisions are at least a more rational approach, which we've done on a variety of other crimes. A bill that was passed out early this year.
Most recently, Senator Calderon's with regard to
right. So that's another approach that you could consider in terms of coming to a solution.
So I'm going to ask if we might just put the bill on hold. We've got many other authors yet to present. We could have a little reconvening.
Happy to do that, Senator, although what was just described and what I think you were open to is certainly something we could live with. If you would be willing to work with me going forward, I would commit to take an amendment that would narrow the forfeiture provision for the bag limit violations only to the ill-gotten gain from that violation.
I'm going to see if we can't in the next hour or so, because we've got maybe a couple more hours work to do, see if we can't work something out. I suspect that we can, because I think we're working toward the same end. Okay?
Thank you.
Thank you. So we'll see you back before we adjourn today's meeting.
Very good.
All right. Thank you, and thank you to all your witnesses. We're going to move to item number 5. Assemblywoman Torres' AB 337. Welcome to our committee.
Thank you, Chairman and members. Assembly Bill 337 would help young adults be productive in life by not letting minor mistakes from their youth be obstacles to that productivity. This bill ensures that people who are eligible to seal their records are informed about their right to do so. Assembly Bill 337 directs Judicial Council by January 1, 2011 to develop the informational materials explaining the eligibility and procedures to seal or destroy records. This bill also directs Judicial Council to develop a form to petition the court for the sealing and destruction of records. The bill does not deal with the records of juveniles who commit serious crimes and does not make any changes to the law on which court records can or cannot be sealed. I ask for your aye vote.
Thank you, Assemblywoman Torres. Witnesses in support.
Glenn Backus for Ella Baker Center for Human Rights in support.
Thank you, Mr. Backus.
Karen Shane, Legal Services for Prisoners and Children. All of us are none. In California Coalition for Women Prisoners in Strong.
Why don't you push that button and give that to us one more time?
Karen Shane, Legal Services for Prisoners with Children, All of Us or None, and California Coalition for Women Prisoners in strong support.
Great. Thank you, Ms. Shane.
Jim Lindberg, Friends Committee on Legislation of California, also in strong support.
Thank you, Mr. Lindberg.
David Warren, Taxpayers for Improving Public Safety, in support.
Thank you, Mr. Warren. Anyone else in support? Anyone in opposition? I don't think there is any. Senator Benoit.
Could you briefly address the cost versus current process? It seems to me that it's a well-intended bill, but are not there already provisions? Are not people aware that they're? I think you know what I'm trying to get to.
The costs have been removed, and the creation of a form that could actually be downloaded from the internet, that was the voluntary from the judicial courts.
But they're not currently notified of this in some other fashion?
There is no outreach to notify juveniles that this is an option for them.
All right. Thank you. I'll be supportive of the bill.
Thank you for your question, Senator Benoit. I think it's a great bill, Assemblywoman. Thank you for moving it forward. I think it is rather straightforward, and will just provide those who are in need of this assistance and the information that's already granted them by current law will be very useful to them.
And I just, in closing, I want to say this is a great bill, and I wish I could take credit for this great idea. It was not my idea. It was an idea that came out of a meeting that I had with constituents in the district, seniors and members, leaders in the community that represent young people. So thank you so much.
Gracious acknowledgement. Thank you.
Move the bill.
All right. Senator Benoit moves the bill. No other comments, questions from the committee. We did allow for oppositional voices. There were none. We will call the roll.
Thank you.
Leno?
Aye.
Leno, aye. Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Huff? No. Huff, no. Steinberg? Wright?
As you know, we're missing some members, so we'll place that on call and we'll take it up later in the meeting.
Thank you very much.
Thank you, Assemblywoman. Committee members, we have a communication from Speaker Bass, and she is respectfully requesting permission to allow Assemblymember Fiona Ma to present her two bills on our calendar today. They would be AB 750 and AB 845. We want to welcome Assemblywoman Ma. $750 we'll take first, which is our item 12, and then move on to 845, which is item 15. Welcome.
Thank you, Mr. Chair and members. I'm happy to present on behalf of Speaker Bass, AB 750, a bill to provide local law enforcement and counties a proven reentry model to reduce recidivism. As you know, ensuring successful reentry for offenders is emerging as a major priority in California, considering California's recidivism rate. As the state faces an unprecedented fiscal crisis, we must rethink corrections and search for solutions that are good, both good for public safety and good for the budget. Repeat offender crimes claim new victims and reoffend at a cost of $50,000 a year per prisoner. AB 750 establishes a model for reducing recidivism among non-violent offenders based on a program called Back on Track. This San Francisco program has been named as a national model by the National District Attorneys Association for its re-entry initiative of low-level, nonviolent, first-time felony drug offenders. Since the program began in 2005, fewer than 10% have reoffended, compared to the 53% recidivism rate among those sent to state prison for the same crimes. The program is strict, which works through a combination of incentives and accountability measures. Participants must complete a rigorous training program while being monitored by the court, resulting in a program that comes at a fraction of the cost, averaging about $5,000 per participant. Local law enforcement can benefit from the guidance of model programs like this. AB 750 will provide local agencies interested in improving safety and saving money some guidance on a model that other counties can follow. With me is Lenore Anderson from the San Francisco District Attorney Kamala Harris's office to talk about the program, and we have other witnesses here as well.
Thank you, Assemblymember Ma, for presenting on behalf of Speaker Bass. Ms. Anderson, before you begin, I'm going to have to ask your indulgence. I have to leave to get to committee to present a couple bills before B&P on the Assembly side closes down. I'm going to pass the gavel to Senator Huff, and if you could just address one thing, first put me on the record, huge supporter of the success of District Attorney Kamala Harris's Back on Track program. I know she has reduced recidivism rates among this population significantly from 70%. I think the number might be 12 or 15. You'll correct me. The one question I would ask if I were here, if you could answer to Senator Huff, is given that San Francisco has had this success without this law in place, why it is important for us to put the law in place. I'm sure you've got that answer. I hope I'll get back before you finish, but if not, excuse me.
Great. Thank you, Senator. Lenore Anderson, San Francisco District Attorney Kamala Harris's office. In direct response to your question, Senator Leno, the opportunity that we have is to provide guidance to other counties for replication. We've had some success. We think this is a very promising model in San Francisco, and we'd like to codify the program in such a way that other counties can replicate it, and replicate it in a way that's very similar to what we're doing. It's a unique program. It emphasizes accountability, and that's why it's been successful, and so we wanted to make sure we had that opportunity for other counties to do as we've done. So that's why we're interested in replication.
Thank you. Next witness.
So the other speakers can proceed. David Warren, Taxpayers for Improving Public Safety and Support.
Charles Milione from Legal Services for Prisoners with Children, and I'm also speaking on behalf of All of Us or None and the California Coalition for Women Prisoners, and we are in support.
Glenn Backus for the Ella Baker Center for Human Rights and Drug Policy Alliance in support. Thank you.
Jim Lindberg, Friends Committee on Legislation of California in support.
Sylvia Solisha on behalf of City of Los Angeles Mayor Antonio Villaraigosa in support.
Liberty Sanchez, California Public Defenders Association, and on behalf of Ignacio Hernandez, who had to scurry out, CACJ in support.
Gail Stewart on behalf of Bonnie Dumanis, San Diego County District Attorney, in support.
Any other witnesses in support? Any witnesses in opposition? Seeing none, we'll bring it back for questions and comments. Okay, I have no questions. Would you like to close?
No, thank you, members, for your support.
All right. Please call the roll. Oh, I'll do a courtesy motion. We'll place that on call for the other members who, a lot of things going on right now.
Yes.
And you're going to present item 15 as well?
Yes. Good morning. I'm proud to present, also for Speaker Bass, AB 845, a proposal sculpted to ensure California is in the best position possible to maximize opportunities available through the Second Chance Act. Reentry is emerging as a major priority for combating recidivism. As you know, the state's recidivism rate is over 70%, which means that for every 10 prisoners released, 7 of them will offend within 3 years of being released. In an effort to reverse these current trend, the bill does the following. 1, it bestows the task of executing the requirements of the Second Chance Act upon the California Reentry Advisory Committee under the Department of Corrections, and it also extends the sunset date until January 1st, 2014 to provide adequate time for the entity to carry out their original and new responsibilities. 3, requires the committee to develop a 5-year comprehensive strategic reentry plan as stipulated by the Second Chance Act to guide the development and implementation of the demonstration projects. And 4, requires the committee to develop a comprehensive reentry services resource guide and make it publicly available. With me today is Kimberly Wong of the Los Angeles Public Defender's Office and other members.
Good afternoon, members. I'm here on behalf of the California Public Defenders Association, and we thank you for considering this important bill. I was a part of a program that you may have heard of, which is the Women's Reentry Court. And the Women's Reentry Court is an example of a collaborative effort that addresses recidivism, that emphasizes individual accountability, and saves taxpayer money across the board. And I've been involved in this from concept to implementation in LA County. The Women's Reentry Court has been in operation for approximately 2 years. The CDCR is another large partner of this project, and I'm proud to report that the program boasts an 80% success rate, and we're talking about women. This program focuses on women who have been to prison multiple times, who have decades of substance abuse addiction histories, and they are thriving. And just recently, about a month ago or so, we learned that we won the NACO Award for this program. But it's an example of what comes together when stakeholders invest their taxpayer money wisely and, addressing public safety. Thank you.
And who would be the second primary witness then?
My name is David Warren.
Perfect.
On behalf of Taxpayers for Improving Public Safety, one of the most significant issues we face inside the prisons is the fact that I keep seeing the same faces over and over again as they violate their parole because they have left the prison without a plan, without a safety net, and without the support necessary to prevent their return. This bill would provide the framework to assure that that changed. For that reason, we support the bill.
Thank you. Other witnesses, if I could have your name and who you represent and your position, please.
Karen Shane, Legal Services for Prisoners with Children, All of Us or None, and California Coalition for Women Prisoners in Support.
Thank you very much. Next.
Mr. Chairman, members, Dan Filisato on behalf of the Los Angeles County District Attorney's Office. We are in support of the bill, as Ms. Wong stated. Also, that one fact that wasn't mentioned is that there is some federal money that has been set aside for this program.
Yes.
And so for those reasons, we are in support.
Thank you very much.
Jim Lindberg, Friends Committee on Legislation, California, in support.
Thank you. Any other witnesses in support? Any witnesses in opposition? Seeing none, questions, comments from committee members? Would you care to close?
Respectfully ask for your aye vote.
The bill has been moved, and we'll call the roll.
Leno? Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Huff?
Aye.
Huff, aye. Steinberg? Wright?
The bill has 2 votes. As you may notice, there's a couple of people missing.
Thank you. Thank you, members.
We will get back to it later. Thank you. Okay. Who's next? Mr. Solario, you have? Okay. Okay, it'll be item number 18, AB 1053. We understand you have 2 bills. So if that one's okay, we'll go with that first.
I do. Thank you. Senator Benoit and Senator Huff. Looks like we got a Republican Public Safety Committee here. But I'm surrounded by Republicans in Orange County, so I'm okay. I feel safe. Senators, I would like to first acknowledge that I accept the committee amendments as they relate to their recommendations on page 18 of the analysis, and that is regarding the interstate compact provisions in the bill. This bill addresses 2 things. The first portion of the bill would require the Department of Juvenile Justice to place youth who have either been aged out or completed their maximum confinement time on supervised parole within 90 to 120 days prior to discharge from custody. During that time, the youth would also receive reentry counseling, because many of us believe reentry services such as employment training, housing, and access to health care services are essential for preventing formerly incarcerated youth from re-offending. The second portion of the bill addresses the state's need to enact a new interstate compact for juveniles. While CDCR, I believe, was slow in notifying the legislature of the urgency to enact the new interstate compact, it is important, vitally important, that we address the situation now so that we can continue to oversee, supervise, and coordinate the interstate movement of juveniles. This bill has no opposition, incurs no state costs, and I respectfully ask for your aye vote. I do have here with me today Don Spector with the Prison Law Office, as well as Joyce Hayhoe with CDCR to testify in support of the bill.
Well, thank you for your presentation, but would you briefly also discuss the other provisions of the bill that deal with the early release of juveniles?
I did speak to that.
I'm sorry, I missed that.
No, that's okay.
We went through it pretty quickly. That part is of concern.
It's succinct, so I'll read that part again. The first portion of the bill would require the Division of Juvenile Justice to place youth who have been either aged out, 25 years, or completed their maximum confinement time on supervised parole. So they're still in state custody within 90 to 120 days prior to discharge from custody. Right now, what happens with these category of youth is they, for example, turn 25, they open the doors, here's $200, and they're not placed on any type of supervision of any type, let alone provided any suggestions on, you might, try to seek out this nonprofit for ideas on housing or job training. We, as you know, are doing more and more in the arena of reentry services for adults. This would provide something comparable for youth that are, again, aged out or maxed out. Pretty much anybody that gets released prior to those two situations are placed on some level of supervised parole, and I think it's important that we have folks that leave one of our institutions on some level of parole supervision.
I have concerns about that portion in the sense that the people who at that age are still there because they won't cooperate and won't participate, haven't shown propensity to be part of those types of programs to let them out early to do it. I would rather have seen those offered after their time out.
Right. And we did consider that, but because at that point they're no longer, part of state custody, we're unable to do anything that would be after. But this at least provides some level of parole supervision, whereas now there is none.
Well, taking the compact and putting it in the same bill is a very politically astute move. So thank you for that. Let's hear from your witnesses. That was a request
of the administration, and I helped them with
Let's hear from your witnesses. Two primary witnesses in support, please.
My name is Donald Spector. I'm the director of the Prison Law Office, who've recommended that the Assemblyman do the part of the bill about the DJJ release of offenders. We think this is better for public safety because these individuals are going to be released anyway in just a few months. It's better, and you're right, they're high risk. It's better to provide them some services with even the parole supervision part of it there than to provide them no services at all. They're at less of a risk if they get some services than they would be if they don't get any. You should also be aware that they are still under parole supervision during this time, so if they do commit an offense or other kind of misconduct, the parole revocation proceedings can be instituted. So for those reasons, we support the bill and hope you do too.
Thank you.
Karen Pank on behalf of the Chief Probation Officers of California, and I'll just speak briefly to the other portion of the bill, which is the Juvenile Interstate Compact. We requested that Assemblyman Solario take this forward because in May we learned that after the 35th state joined on to the compact, it would release the 1955 old compact in which we all now currently belong to and transfer juveniles between the states. And so without that, it would sunset in December of this year, leaving us without the ability to transfer for kids out or have a judicious way to transfer the appropriate kids in. So for those reasons, we support the bill.
Thank you.
Joyce Hayhoe, Assistant Secretary for the Department of Corrections and Rehabilitation. I have Rachel Rios, who is our Director for Juvenile Parole, here to answer any questions with regard to the compact portion.
Quickly, how many states have ratified? 40. So it is going to kick in for 35 years. Okay, or 35 or more states.
40 states have
Thank you very much. Next witness in support, your name and your position, please.
Charles Milione from Legal Services for Prisoners with Children. All of us are none, and the California Coalition for Women Prisoners, and we are in support of this bill.
Thank you, David.
David Warren, Taxpayers for Improving Public Safety, in support of the bill.
Others in support? We may need to make some room at the table here.
Liberty Sanchez, California Public Defenders Association, in support.
Okay, and we definitely make some room for these other folks, please. Thank you.
Arnulfo Medina with the California Youth Empowerment Network. We're in support of this bill.
Thank you.
Desiree Alarcon, California Youth Empowerment Network Steering Committee.
Press the button. I'm sorry.
Desiree Alarcon, California Youth Empowerment Network Steering Committee member, and we're in support of this bill.
Thank you very much. Any other witnesses in support? Any witnesses in opposition? Comments, questions? You may close.
I respectfully ask for your vote.
Thank you very much. Please call the roll. Oh, I'm sorry. I need a motion.
Courtesy motion.
We have a courtesy motion.
Leno, Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Huff?
No.
Huff, no. Steinberg? Wright?
We'll keep the bill on call.
Thank you, Senator.
Thank you. And we now move to item 22, AB 1439. Mr. Solorio?
Thank you, Senators. This bill is about making government more efficient. As you know, we need to be more efficient with the resources we have. We had a Assembly Public Safety hearing earlier in the year, and we found out that the state spends $1.5 billion on gang violence prevention, intervention, and suppression. However, that money is distributed through 42 different revenue streams and is managed by 14 state offices and 8 state departments. This bill would require the Office of Gang and Youth Violence Policy to create a working group to streamline anti-gang funding in order to channel resources to the most effective and evidence-based programs. I would also like to say I do appreciate the amendments that suggested by the Republican staff and the members, and I would accept those. The nature of those amendments are just to say that we're not giving the chair of the Office of Gang and Youth Violence Policy any more powers than they already have through statute.
Senator, sorry if I could interrupt you at that point. Just to clarify, to make sure for the record that amendment is clearly understood by all parties, this is on page 2, line 3, inserting after the words "the director shall," inserting "subject to statutory limits and directives," going back, consolidate and streamline existing state agency. I believe that's the wording that you've been agreed to.
And I do
for the record.
Accept that.
Okay, we appreciate you accepting that author's amendment.
Thank you. This bill has no opposition and incurs no state costs. Again, we're actually just trying to create more efficiencies with what we're currently doing. I respectfully ask for your aye vote.
Thank you. Any witnesses in support? Any witnesses in opposition?
I move the bill.
Bill has been moved by Assemblyman Huff as amended. Would you care to close?
I ask for your aye vote.
Okay, with those amendments, I'll be in support. Would you please call the roll?
Leno? Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Huff?
Aye.
Huff, aye. Steinberg? Wright?
That bill is on call. We'll get to it.
Senators.
Thank you. Yeah, members in the building, we are looking for authors in the Senate Public Safety Committee. If you'd like to get done, your time is now.
On 1439, Benoit was aye. Huff, aye.
Powerful.
Oh, and you took amendments, right? Yes. Thank you.
Okay, coffee time. I'll be right back.
We've got a bunch on call. 13, 14.
You're up, Jimmy.
17, 20.
Thank you, Senator Nielsen. Item 20, AB 1166. Please,
Mr. Chairman and members, I can give you the long and storied history of this particular provision, but it...
could we prefer the
brief version?
That'd be fine.
I'm very happy to proffer the brief version. Basically, this bill clarifies that the so-called en banc referral of a parole suitability decision is not going to be considered a hearing, but rather a review. That's consistent with what is historically in the Title 15, a decision review. We've accepted a number of amendments that the committee did offer that I think clarify it. Basically, that the en banc panel would review the entire record of the hearing that resulted in the tie vote. That's consistent with Title 15 and historic practice at the board. that the review would be limited to the record of the hearing and the transcript and the audio tape are, in fact, that historic record. That's consistent with the regulations in the past, so that would restate it. Very particularly important point is that in the en banc hearing, where there is public participation, that there can be no new evidence considered or presented to the panel or to the board for their review. There can only be limited, the comments, public comments could only be limited to the record that was before the panel that made the decision. And any commissioner who was involved in that instant hearing would recuse themselves. Those are the amendments we've accepted. Yes, sir.
And for the record, the amendments have just been passed out. These are the amendments you're referring to.
They appear appears to be the ones that we worked out with your staff this morning.
Okay, and then we will proceed on the bill as accepting your amendments as author's amendments, and we have witnesses in support.
Thank you very much. Renee Hansen, Department of Corrections and Rehabilitation. We're the sponsor of this bill. With me, I have Anna Avisa. She's the chief counsel for the Board of Parole hearings to help me answer any technical questions you may have. But I think the Assembly member has done a good job of presenting what we are looking for. And we'd especially like to thank the committee for working with us on these clarifying amendments.
Working you over.
Working with us for hours and hours, and here we are. Thank you.
Okay, thank you very much. Second witness, primary witness. Okay, anybody would like to just add their position of support?
Thank you. Dawn Kapke with McHugh and Associates on behalf of Crime Victims United of California in support.
Thank you.
Mr. Chair and members, Corey Salzillo on behalf of the California District Attorneys Association in support.
Thank you. And I suspect we have a witness in opposition somewhere in the building. Witnesses in opposition.
Senator, I hate to be so obvious. David Warren, Taxpayers for Improving Public Safety. Thank you. Regrettably, we didn't have an opportunity to review the amendments before today, and I apologize to the author because we were of the belief when Mr. Steinberg announced there'd be no hearing today that there wouldn't be a hearing today, which is why our letter didn't get there to the member in time. We're in opposition based upon the very basis of the two judicial opinions. We strongly believe that in order to assure that due process is granted, that the evidentiary proceeding before the entire panel of commissioners should be open, because I just give you this one example, and that is a statement is made and a commissioner has a question about the interpretation, understanding, or whatever the statement, and because there is no person to respond to that question, is left open, and that individual, the parole nominee does not, or his attorney does not have an opportunity to respond. The same thing to a witness who opposes the request for parole. That is a very important issue which is not addressed by just using a recording or transcripts, and for that reason we would ask that you reject this bill. Thank you.
Thank you. Any other witnesses in opposition? Comments from the committee? The bill has been moved, and maybe you can address those concerns in your close, Senator.
Mr. Chairman, the standing that was requested just now by the witness, who I respect and have worked with respectfully before, has never existed. The Penal Code does not allow that standing for a individual party. Those who would advocate for the inmates are allowed to present to the panel written communication, and that is all, other than what would be expressed from their attorney. This en banc opened up a new area that it's not even legal. So there's no need to address that concern. If there be the voice of the supporters of the inmate are presented through the letters and through the attorney who represents them the entirety of the hearing. And that is, in fact, on the record and the transcript, everything that the attorney says.
Thank you very much. Does that constitute your close?
That's closing.
Thank you very much. We will call the roll.
Leno? Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Huff?
Aye.
Huff, aye. Steinberg? Right.
Your bill has 2 aye votes. We will keep it on call.
You do have a time for a call, Mr. Chairman?
Yes.
All right. I thank you.
Absolutely. We're going to be here quite a while yet.
Could you make this announcement? We just learned about this.
Okay, for purposes of everybody keeping up on their scorecards here. Author Calderon, AB 819. That bill has been pulled from today's agenda. That's file number 14 has been pulled. You bet. We have another author?
The vote only if you wanted to. Item 25 is a vote only if you wanted to open the roll on it.
You want to do that? Then I might. Okay, for purposes, again, of moving the agenda forward while we're waiting for authors, we have one item that's vote only, item 25. And to get that process started, we will open the roll on item 25. Yes. As amended.
Would you like staff to describe the amendments?
Yeah, please, if you would, that would be good if you could describe the amended.
The Torlakson bill creates a new misdemeanor for sale or providing of nitrous oxide to minors. Currently, the bill is drafted to include a fine of up to $2,500 and a year in jail. And the bill is silent about whether the prosecution has to prove intent or knowledge. What the bill, as amended, will do is be a standard misdemeanor, 6 months maximum jail term, $1,000 maximum fine, and the prosecution won't have to prove knowledge or intent, but the defendant will specifically have an affirmative defense to state that he or she reasonably believes the person was under 18.
Thank you for that explanation, and we recall the previous extensive hearing on that bill.
Over 18, that's it. Sorry.
Yeah, okay.
That would make it a little unusual there.
Thank you. With that, we will vote on the bill as amended. Anybody need a motion to move the bill for that purpose? So moved by Senator Huff. Please call the roll.
Leno. Benoit.
Aye.
Benoit, aye. Cedillo. Hancock. Huff. Huff, aye. Steinberg. Wright.
Okay, that bill is on call. Members, with bills pending before the Senate Public Safety Committee, please come to the room now. We are ready to hear additional bills, and we are waiting for authors. We are looking for authors. We have bills pending from Assembly Members Carter. Has that one been done? Oh, these are the ones that are still pending? Okay, we're looking for Assembly Member Liu, De Leon, Davis, and Fuentes. So we're down to 4 authors. And I understand at least 1 or 2 of those are actually presenting in another committee at this time. So we will stand by. Oh, we're waiting on that.
Called. If they're telling the truth, they should be underway.
Okay. All right. Thanks. 962 De Leon. It's supposed to have quite. Oh, yeah. Oh. Assemblymember Davis, thank you. Your timing is impeccable.
Oh, well, thank you, Mr. Chairman.
You can use the podium if you like.
Oh, podium, okay.
This will be item 21, AB 1369.
Yes, sir. Thank you very much for giving me an opportunity to present AB 1369. This bill deals with giving and granting the opportunity for boards of supervisors to be able to implement an electronic monitoring program for some of its inmates, and therefore allowing our counties to comply with the federal requirement that we have a cap, a mandatory cap, on the capacity of operating our county jails throughout the state. Having said that, we realize that we also have a budget challenge in our state and in our counties, and quite actually nationally. This tool of using electronic monitoring will be really effective for our counties. And through this effort, I would respectfully ask that we allow the implementation of AB 1369 so that our county boards of supervisors can employ as an option utilizing the electronic monitoring for some low-level felons in some of our county jails throughout different 58 counties in California. With me today is Mr. Wayne Beloit, who is the consultant working on this measure and is available for any questions that you might have.
Thank you.
I do accept the amendments.
That's what I was going to get to.
Yeah, I do accept the amendments of the committee. Thank you.
Okay, then as the bill is amended, please, Mr.
Good morning, Mr. Chairman. Lieutenant Wayne Beloit on behalf of LA County Sheriff Lee Baca. We have implemented home electronic monitoring. It has been very successful for us. This is a natural expansion of it, and we strongly urge your support. Thank you.
Thank you. Other witnesses in support? Is there any opposition? No opposition. Witnesses?
No, sir.
Okay. Questions, comments from the committee? The bill has been moved by Senator Huff. Please call the roll.
Leno? Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Huff?
Aye.
Huff, aye. Steinberg? Wright.
Senator Davis, this bill will be on call.
Thank you, sir. Appreciate it. Thank you.
Yes. Senator
Hancock, aye.
Thank you. Senator Member Liu. We got two bills. We have three bills. Do you want to proceed in file order, Mr. Liu? Or? Okay,
Yes.
So that would be AB 951 first.
Great. Good
Please
morning,
present.
Senators.
Good morning.
AB 951 is a bill that has received bipartisan support. It increases penalties to charter carrier companies that violate safety standards designed for passenger safety. This bill is in response to a tragic incident in Colusa County where a bus crash resulted in an injury of 34 and a death of 11 people. In reports about the case, the driver of the bus did not have the appropriate license to drive a charter carrier, and there are other safety defects as well. The bill here is sponsored by the California Bus Association, and I have witnesses here in support.
Thank you.
Mr. Chairman, members, Josh Panay on behalf of the California Bus Association, 80 bus companies throughout the state of California, and we're in strong support of the measure and would be pleased to answer any questions for you.
I commend your association for being in support of such a strict regulation on your own industry.
Well, over the years, the Motor Coach Association has attempted to bring safety as the first and foremost goal. And it's unfortunate that this accident, this tragic accident, had to happen to bring it to the light of the legislature. But we've been strongly supportive of safety issues and measures, so we appreciate that.
Thank you. Any other witnesses in support? Is there any opposition? I don't believe there's any noted in the file. Any comments from committee members? Bill's been moved by Senator Hancock. Thank you very much. You may close.
Resolve the request and I vote.
Please call the roll.
Leno? Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Hancock, aye. Huff? Huff, aye. Steinberg? Wright?
That bill is 3 votes. It will be on call.
Thank you.
And then we proceed next. Is it 1122?
Yes.
AB 1122, Senator Assemblyman Liu.
This bill was heard by the Public Safety Committee last week. We took several amendments. We worked with all the stakeholders as well as with committee staff. What the bill seeks to do is to protect animal welfare by preventing their unregulated sale of pet animals on roadsides and in parking lots. Oftentimes, puppy mills and backyard breeders use parking lots and roadsides as temporary vending locations because regular pet stores won't take their pets. And because the current health and safety regulations do not apply to these locations, many of these pets purchased are sick or ill or maltreated. Several counties, such as Sacramento County, Kern County, and LA County, have all banned the sale of animals on roadsides. And AB 1122 basically makes this statewide. We have witnesses here in support of the bill.
I'm Barbara Schmitz. I'm here on behalf of the California Animal Association. We're one of the co-sponsors of the legislation. In addition to our sponsorship of the bill, also the State Humane Association, which represents animal control officers as well as humane investigators statewide, is a co-sponsor of the bill as well. And I'm happy to answer any questions. Thanks.
Well, thank you very much. This is a bill that has had extensive hearings already. And is a very important bill and deserves a fair airing. However, because of the size of our agenda today, I'm going to ask for one other primary witness in support of the bill, and then we'll ask the others who would like to just indicate their association and who they represent their position. So who would be like the second primary witness? Yeah. Corey's always good, yeah.
Mr. Chairman, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office. We're in strong support of this measure. In LA County, our office quite frequently gets complaints filed with our office for individuals who buy very expensive pets from what they thought were reputable breeders, where it turns out that the animal, while it looked fine at purchase, actually had some very serious medical issues. Quite often, the animal winds up dying shortly after purchase. Other cases I've been involved with, an individual had to expend almost $10,000 on medical bills in order to save their pet. We do not have this problem from breeders who have locations where an individual goes to, purchases the pet there. However, the big commonality we see in our complaints are individuals who are buying pets from, parking lots, supermarkets, flea markets, parking lots, these type of situations. It's my understanding that the committee, that the author did take amendments to include or to exempt the sale at live animal shows that have the proper permits, and for that reason we are in support.
Okay, other witnesses in support, if you could state your name, your association, and your position, please.
Dave Middlesworth. I'm representing the Humane Society of the United States. We are in support.
Thank you.
Esperanza Zuniga, representing United Animal Nations, in support.
Thank you very much.
Jill Buckley with the American Society for the Prevention of Cruelty to Animals, in support.
Thank you. Any other witnesses in support? Thank you. Witnesses in opposition? No witnesses in opposition? Okay. Members' comments, questions? That was the last one, but we'll accept it on this one also. Thank you, Senator Hancock. The bill has been moved. Would you care to close, Senator?
Just that we've taken several amendments and worked with the stakeholders and we respectfully request an aye vote from the last hearing.
Thank you very much. Okay, call the roll.
Leno? Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Aye. Hancock, aye. Huff?
No.
Huff, no. Steinberg? Right.
So we have 2 to 1. The bill is on call. Thank you. And your third bill is item number 24, AB 1516. Yes, please go ahead.
Thank you. AB 1560 ensures justice in criminal cases by restoring the prosecutor's ability to have their mental health expert examine the defendant. The recent California Supreme Court case, Verdon versus Superior Court, overturned 35 years of case law and basically asked the legislature to fix this problem in statute. AB 1516 fixes this by amending the California Penal Code to authorize courts to order a psychiatric examination by a prosecution expert when the defendant puts a mental health in issue. We have witnesses here in support, and respectfully request an aye vote.
Okay, thank you. And witnesses in support?
Mr. Chairman, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office. We are the sponsor of this bill. Before I begin, since Mr. Leno is not here, I was told that Mr. Leno had an amendment he wished us to consider, which would change the bill from the court shall appoint to the court may appoint. Discussing that with the head of our habeas division, we would accept that amendment. I guess I don't know how we would. If it's
Well, you would propose that amendment.
We would propose it.
And we'll see what the author says about accepting it. But,
I'm fine with it.
Okay, and staff, since Mr. Leno's not here, are you in concurrence with those comments?
Yes, that's what the chair asked me to talk to the sponsor about. So
Okay.
it would be may instead of shall, so that there would be court discretion in whether or not to appoint an expert.
Thank you. Okay. You want to finish your comments?
Just that we have amended the bill to try and provide to make clear our intent is only to, this bill only deals with the appointment of a prosecution expert. Nothing in our bill is intended to restrict a defense attorney's ability to bring a motion that, in the particular case, the testimony, if it's admitted, would violate one of the defendant's constitutional protections. That is not our intent. We've tried to make that clear. We are willing, if the committee thinks that we still need to work on that language, we are open to. We tried to do that as best we could. This is a technical area of the law, and I have my head of my habeas corpus division here to explain the bill in detail.
Would you like to be the second witness on this bill, please?
Good morning. Brentford Ferreira, Deputy District Attorney. Mr. Chair and the committee, thank you for letting me speak. Verdon versus Superior Court dealt with an unintended consequence of Proposition 115. All the Supreme Court said was, we are bound totally by Proposition 115, and there's nothing in the discovery provisions of 115 that allows for the order that we previously had been making under case law for 35 years. And since Proposition 115 restricted us to just the discovery provisions that were in the bill, in the proposition, therefore we cannot make this order, and invited the legislature to pass legislation that would allow for such an order. Some of the opposition to the bill, as Dan said, it deals with whether or not we're going to violate defendants' constitutional rights. But the case law has long held that if the defendant places a mental issue in evidence through the testimony of his own expert, that's the only time we get to have an expert appointed. And there's a waiver in that instance of his constitutional rights. In order to emphasize that we are not seeking anything other than the ability to have the order appointing the expert made, we've stated in the legislative intent that there is no intent to disturb in any way the body of case law that currently exists that would limit the prosecutor's rights to certain tests and for the experts to ask certain questions. And we have also asked to codify the procedures that previously were only mentioned in case law that would require prosecutors to set forth the tests that are going to be used by our own expert and give the defense an opportunity to come into court and make any objections to those particular tests that the defendant might want to make, and the judge would have to make a threshold finding that these tests are really necessary to an issue in the case before we would get our expert appointed.
Thank you. Very good. Additional witnesses in support?
Dawn Kepke with McHugh & Associates on behalf of Crime Victims United of California in support.
Thank you.
Mr. Chair and members, Corey Salzillo on behalf of the California District Attorneys Association in support.
Thank you. Any other witnesses in support? All right. How about witnesses in opposition?
Good morning, Mr. Chair, members. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice. Let me just start off by saying that this is the first I heard of the amendment to move from mandatory to discretion. I don't know if that would change our position, but we will take another look at that. I want to thank the author and the sponsors for working to address some of our concerns throughout the process on this bill. We've taken the position that there should be some restrictions. As an example, you shouldn't be able to ask a defendant about the facts of the pending case, and that was something that was protected by case law, and the sponsors and the author have agreed to that. I think that they're moving in that direction. So it's moving in the right direction. We still have some concerns. We do want to state for the record that the court left open the question of whether or not these examinations are constitutional, and so we do reserve our position based on the principle of these may in fact still be unconstitutional depending on the circumstance. So that's why we're not in support of the bill yet or have withdrawn our opposition, but I do want to thank the sponsors and authors for working with us.
Thank you very much. And any other witnesses in opposition? We have a comment from Senator Wright.
I was going to move the bill.
The bill has been moved by Senator Wright. Any other comments from members? Would you care to close?
We respectfully request an aye vote.
The bill is moved as amended. Assemblyman?
We respectfully request an aye vote.
Thank you very much. Please call the roll.
Leno, Benoit.
Aye.
Benoit, aye. Cedillo. Hancock. Hancock, aye. Huff. Huff, aye. Steinberg. Wright. Wright, aye.
Yeah, we'll keep that bill on call.
Thank you.
Thank you very much. Can we go through and do for those members who are here, a vote on the bills that are missing? Because we're down to one or two. Would that be a lot of trouble?
Here's my cheat sheet. If you just follow this,
Okay.
that'll work the best.
He's on his way down.
Who is?
He's on his way.
What do you think? Should we start this or not?
Really on the way.
I don't know.
Let's see if Senator Wright can stay.
I could run through the bills and votes now, or wait a couple minutes for De Leon. Are you in a hurry? You want to get back?
We're just told De Leon's on his way.
We're told De Leon's on his
All right,
way.
why don't I read it down?
Or you?
I mean, since I'm in that thing where I didn't hear half the testimony or anything anyway, I mean, why should I get it screwed up now?
Well, you know what? Since I'm going to have to go to, I think I'm going to ask you we go through these.
Okay.
And
So the best way to do is, if you can read my handwriting, is just start from the top and go down.
okay. Given that we're still waiting authors, we're going to go through the bills on call one time to allow those members who are here to add on that were not here for the earlier bills. So we'll start with item number 1. Please call the absent members. SJR 11.
Cedillo. Hancock. Hancock, no. Steinberg.
You abstain.
Which one is this?
Guantanamo Bay runner. Back on call. Item number 3, AB 11, fewer IIDs. Please call the absent members.
Is that number item 91?
Yes, AB 91.
Okay.
AB 91.
Cedillo. Hancock. Hancock, aye. Steinberg. Wright.
No.
Wright, no.
Item number 2, SJR 12, Benoit, criminal alien reimbursements. Please lift the call.
Excuse me, is that as amended?
Yes, as amended by the.
So that alien is replaced with undocumented?
Yes, in the text of the resolution. Yes.
And the chair voted for that.
The chair voted aye. Please call the absent members.
Cedillo. Hancock. Hancock, aye. Steinberg. Wright.
Aye.
Wright, aye.
Thank you. The bill is back on call. Item number 10, AB 653 by Fuhr. I can't read what that is. Oh, marital privilege peace officers. Please call the absent members.
Benoit,
Not voting yet. Aye.
Benoit, aye. Hancock,
Aye.
Hancock, aye. Steinberg, Wright, Wright, aye.
That bill is
That bill is out. We'll leave it open for members.
have to, it's only Senator Steinberg and he can act.
Oh, okay. That bill is out. Item number 4.
Item number 4 was put over.
Okay. Next item for vote, item number 9, AB 589 by Assemblymember Cook, veteran contracts. The chair voted for that bill. Please call the absent members.
Benoit,
Aye.
Benoit, aye. Hancock,
Aye.
Hancock, aye. Huff, Huff, aye. Steinberg, Wright voted aye. I have,
You've already voted aye on that bill.
yeah.
That bill is out.
That bill is out. Item number 7, AB 438 by Assemblymember Bell. Diversion. Let me just see here. Please call the absent members.
Benoit,
No.
Benoit, no. Cedillo, Hancock,
Aye.
Hancock, aye. Huff,
No.
Huff, no. Steinberg,
That bill is out.
I have read it.
Right, I voted for it before.
I'd Cedillo. I have three ayes.
Just a moment. Chair was an aye. I had
Cedillo, oh, okay.
Yeah.
Okay.
Yes, Cedillo.
We've got that.
4 to 2, okay.
So the next one's item 6.
Yes.
Item 6.
Item number 6, AB 382, has to do with inmate classifications. It's item number 6. Please call the absent members.
Benoit,
No.
Benoit, no. Hancock,
Aye.
Hancock, aye. Steinberg, Wright, Wright, aye.
That bill is out.
4 to 2.
4 to 2.
The next one, the chair set it aside for the moment to have this.
Oh, let's hold off on that.
So we'll just hold it off. There's been no motion. Yeah, in the next one.
The next one, okay. The next item ready for a vote is item number 5, AB 337, Torres. And the chair and vice chair both voted aye. Please call the absent members.
Cedillo, Hancock,
Aye.
Hancock, aye. Steinberg, Wright, Wright, aye.
Leave that open for Senator Cedillo.
We'll leave that bill open for Senator Cedillo. Hopefully we'll be able to return shortly. Next item, item number 12, AB 750, Assemblywoman Bass. We don't have a vote yet from the chair. Huh? Is he going to be supported? Okay, the chair will be supporting that, although he has not yet voted. Let's call the absent members.
Which one?
Leno,
They're going to come
Benoit,
back.
No.
Come back. to
Benoit, no. Cedillo, Hancock,
Aye.
Hancock, aye. Steinberg, Wright,
Okay.
Wright, aye.
That bill is on call with 2 yes, 2 no. Item number 15, AB 845, also by Assemblymember Bass, Reentry Advisory Committee by the Speaker. The chair is supportive of that, isn't it? The chair is supportive. Please call the absent members.
Yes, item 15.
Leno, Cedillo, Hancock,
Aye.
Hancock, aye. Steinberg, Wright, Wright, aye.
We'll put that on call. It has 4 votes. Item number 18, AB 1053, Solario, number 18. And the, one moment, is the chair supporting that?
Yes.
The chair will be supporting that, I'm told, and I have voted aye. We ready to call the roll on item 18? Call the absent members, please.
Leno, Cedillo, Hancock.
Aye.
Hancock, aye. Steinberg, Wright. Wright, aye.
That bill is Bill 8.
That was as amended.
Cedillo, aye.
Cedillo, aye. That's
Cedillo,
item 18.
aye.
Let's leave that on call for the chair.
We'll leave that on call for the chair. Item 22, AB 1439 by Solario, gang violence prevention. And one moment, is the chair?
Yes.
The chair is supportive. He has not yet voted. I voted aye. It has 2 aye votes, Benoit and Huff so far. Let's call the absent members.
Leno, Cedillo, Hancock.
Aye.
Hancock, aye. Steinberg, Wright. Wright, aye.
We'll place that ball. Cedillo's aye.
Cedillo, aye.
And we'll leave it on call for the chair. Item number 20 by Senator Assemblymember Nielsen, Senator Nielsen.
You took amendments at the request of the committee?
The amendments that requested by the committee were accepted as author's amendments. And let's see, which one is that? 20. That has 2 aye votes, Benoit and Huff. The chair is supportive with the amendments. Let's call the absent members, please.
Leno, Cedillo. Cedillo, aye. Hancock.
Aye.
Hancock, aye. Steinberg, Wright. Wright, aye.
Thank you. We'll put that on call. Item 25, AB 1015, Torlakson. This was vote only related to nitrous oxide. And number 25. And it has 2 aye votes, Benoit and Huff. There were amendments taken at the request of the chair, and he will be supportive with those amendments. So item 25, please call the absent members. Hold on one second.
Tell them about the amendments.
Senator Cedillo. Could you do?
Yeah.
The amendments to this bill change the penalty provision that's now up to $2,500 fine and a year maximum in jail. It would make that a standard misdemeanor, which is up to 6 months in jail and up to a $1,000 fine. It doesn't require the prosecution to prove intent or knowledge, but the defendant does have a specific affirmative defense where the defendant could say, I reasonably believe that this kid who bought the nitrous oxide was in fact an adult. And the other provisions in the bill would stay the same. On the second conviction, business license would be suspended for up to a year in the discretion of the court. And again, that the person who owned the store could avoid that business license suspension by showing that they took reasonable efforts to prevent sales to minors.
We'll go ahead and call the absent members on item 25.
Leno,
We can leave it open still for him.
Cedillo, Hancock.
Aye.
Hancock, aye. Steinberg, Wright. Wright, aye.
That bill will remain on call. Item 21, AB 1369 by Davis. This bill has 3 aye votes.
Amended to remove the ROCA concern.
Amended to remove the ROCA concern, and with that, the chair will be supportive. He's not yet voted. It's item 21, AB 1369. Please call the absent members.
Leno, Cedillo, Steinberg.
Home detention. It's been amended to address the
Item 21, AB 1369.
has to do with involuntary home detention.
Wright. Wright, aye.
That has 4 aye votes, and we'll hold it open. Item 16, AB 951, Liu, charter carriers. This bill, penalties. This bill had no opposition. It's supported by myself and two other, Hancock and Huff, so far. And I believe the chair is supportive. And please call the absent members.
Leno, Cedillo, Steinberg, Wright. Aye. Wright, aye.
We'll please place that back on call. Item number 19, AB 1122 by Assemblymember Liu regarding sale of animals.
Okay.
I'm not sure where the chair is. As amended? Is that correct?
No, it's not amended in committee. It was amended.
Previously amended before this committee. It's my understanding the chair will be supportive. This is item 19, AB 1122. Please call the absent members.
Leno, Cedillo, Steinberg, Wright.
I didn't hear the debate.
No opposition came today, but I don't know if it's removed some of it. They took care of the, I believe the amendments took care of the fishermen off the boat situation where they're selling things off the boat, and also the horse show, dog show, cat show, selling at those facilities.
Right, aye.
Right, aye.
And one more item, item 20. I'm sorry, put that on, that bill will be back on call. Item 24, AB 1516, mental health examinations, criminal cases. Assemblymember Liu. The bill has 4 aye votes. Is the chair supportive?
The chair asked for an amendment to have it may instead of shall, so that it was discretionary, and my understanding is with that amendment, he's supportive.
Okay, that's what we know about the chair's position. It has 4 aye votes. We'll call the absent members.
Leno, Cedillo, Steinberg,
And that bill will be placed back on call. All right, thank you. And now we are ready for our next presenter. Is that Assemblyman De Leon? Is that correct? And we understand Assemblymember De Leon is close by.
Sorry about my handwriting.
That's all right. You can tell the blue.
I know.
I added blue
Oh, you did? Okay.
as I was going through those.
Very, 4th of July, I like that.
Yeah, red, white, and blue. Yeah, all right.
For a while. I've always been. Yeah.
Okay, we're ready to resume on item 23, AB 1511. Assemblyman De Leon, if you're prepared, please present.
There we go. Good afternoon, Mr. Chair, members, for allowing me to present AB 1511, a bill to enhance the safety and security of our children while at school. AB 1511 would authorize voluntary collaborative partnerships between local school districts and local district and city attorney offices to improve campus safety. This opportunity was tested as a pilot program in February 2007 in LA Unified School District and was successfully implemented in gang-prone Markham Middle School in the Watts area of South Los Angeles. Markham, a school widely considered to be among the most dangerous within LA Unified School District, has long been plagued by crime and gang violence. The school is surrounded and home to 7 street criminal gangs. In just 2 years, in 2 years alone, after LA Unified School District entered with the LA City Attorney's Office, the program increased students' test scores and graduation rates, and also improved the safety of the school's surrounding community. This model has been tried at other schools within LA Unified School District and has had similar results. AB 1511 would ensure that a consensus via an MOU is established between local school districts and local prosecutors to create this program. Only, let me underscore, if all the parties agree, will this program be authorized to assist students and hopefully improve the academic and safety success of all these children. This is a bill that has been supported in a bipartisan manner. I respectfully ask for your aye vote.
Thank you. Witnesses in support.
Good afternoon, Mr. Chair, members. Edgar Sassuet on behalf of the Los Angeles Unified School District. As Mr. De Leon stated, Markham Middle School is kind of gets notoriety around, Los Angeles, the state, and even the country as being, possessing some of the most unique challenges just in terms of the safety of our students. This program has had has made a huge difference on that campus, so much so that now our superintendent is looking at ways to model this program and apply it at other campuses around the district. Just having the presence of the prosecutor there, it's been a type of a relationship where they've integrated with the students. It's been something that's had buy-in from the community, and we think it's a model that could be used elsewhere around the state. So for those reasons, we support the bill.
Thank you. Any other witnesses in support? Witnesses in opposition? Please step forward.
Good morning, Mr. Chair and members. Valerie Small-Navarro at the ACLU, and we remain in opposition, unfortunately. Essentially, this bill is unnecessary. I appreciate what the author and the witness have said, that this is a great program. Well, it is a great program. People can do it. They don't need a bill. They can go ahead and do it. And unfortunately, the negative and the downside of this bill is that in areas where the prosecution is not as enlightened or as willing to work with people in the community, it actually would be a detriment to kids to have law enforcement on their campus. We already have, I'm sorry, I overstated that. We already have police on campus. As many of you know, there's plenty of law enforcement on campus. This would add another layer, a prosecutor on campus. And it's really unclear from this bill what this prosecutor would actually do. It says improve public safety. Well, that's a very broad term, and it could be good stuff and it could be bad stuff. And I would suggest to you that if Los Angeles is doing this and they want to continue, that's great. If other communities want to do it and they want to continue this with this model, that's great. But I don't think we need it in the law. Your analysis points this out, and the Senate Senate Education Committee analysis pointed out, and on the other side, they also pointed out. So this bill really is unnecessary, and we urge a no vote. Thanks so much.
Thank you very much. Any other witnesses in opposition? Comments from the committee?
So, just for clarity, this bill is permissive. It's not mandatory.
Please.
You enter into an MOU if all parties agree and collaborate, just like the model that was used at Markham Middle School.
So, I'm not clear on I understand I'm not clear on the ACLU's objection if this is already doable. I don't disagree with you, but I'm saying if this is already doable and this is permissive,
Right.
while we may not favor the policy and there are circumstances in which we may not have enlightened city attorneys on campuses, there's no prohibition against that at this moment. Is that correct?
That's correct. There's no prohibition against that at the moment. But it's people can do it.
Just kind of superfluous is, I think, the phrase. So that's simply the only objection.
Well, the concern that we have is that imagine that you're on campus now. You have law enforcement officers currently on campus. Then you bring prosecutors on campus. Basically, you're putting kids in a position where they're getting further and further messages about they're being criminals and bad kids. And instead of preventing and addressing things ahead of time, you're just further creating a terrible atmosphere to be on campus. I mean, imagine if here in this we have a ton of law enforcement already. If we had prosecutors roaming the halls of the legislature in addition to law enforcement, it's a pretty negative model. Although it could be a positive thing, but that's we're not seeing that the positive would work necessarily.
Some on the committee might argue that creates an atmosphere of safety and security. That in environments like inner city schools, that people have more comfort and confidence and a sense of peace in their educational environment when law enforcement officers are present and visible. I know the argument from the city attorney of Los Angeles was that this person played kind of more like an ombudsperson role, and that their role is to help be a resource for students and families to address concerns at the school site and in the community.
Right. Well, I think it can be a good model, and I think there is a good example. But what I don't think we're seeing, the possibility of a negative outcome is very great. And currently, kids with disabilities and kids of color end up getting arrested at a far higher rate. They don't finish school, they drop out, et cetera. So I think, if you keep layering that law enforcement layers on top, there could be a sense of it being more secure, but it's not always the case. I'm not saying 100%. I'm just saying it's not necessarily the case.
Mr. De Leon, there's a concern that you're creating a police state on a campus to create that's adverse to create an environment for
academic enrichment or learning.
Correct.
Thank you, Senator, for your question. I have a lot of respect for the ACLU. We don't always concur with each other. I represent a district such as the one that you currently represent. Well, the vast majority, if not all, the public schools, elementary, middle, as well as high schools, or lower decile schools. And we know that lower decile schools is a euphemism for black and brown schools. When it comes to the poverty rate, when it comes to gang violence, we don't have to sit at a think tank and muse over and peruse data and research and statistics, or see what the latest statistical plan is with regards to CalWORKs mothers or the deaths that take place senselessly. We know it, we live it. This is not George Orwell's 1984 police state environment. I think my credentials have clearly shown since I've become an elected official, and even previous to that I would never move forward in with any type of piece of legislation that would directly or indirectly create a police state environment. This is Markham Middle School was a school that was marked by gang violence, and it created and cultivated, and you use the word quote unquote an ombudsman that fostered and cultivated a relationship with the students. This is a clear case example where I heard could be or can be. We have a clear model that has been very successful. The words are terrible or negative, consequences that can arise from this. This is a collaborative relationship that exists if, in fact, they want to move forward with this type of relationship with the superintendent, the principal, as well as the district attorney or the city attorney. This is something that they want to work together. A city attorney may say, a superintendent may say, we have high spikes of crime in this area, and because of that, we're sending so many kids that are going off to CYA, or what was then called CYA, and we have a pattern that sends them off to county jail, and then from there they graduate to Vacaville, Folsom, Chino, Pelican Bay, and elsewhere. And we want to stop that. It costs the state of California too much money. Let's put a prosecutor there or a city attorney there, and let's develop and cultivate, and let's educate the kids and say, these are the real life consequences and the judicial consequences if in fact you move forward with this type of behavior. And we've seen remarkable evidence, data that clearly shows us that has actually declined. I would never move forward with a measure that puts an in-house prosecutor, and his or her goal is specifically to go out there and finger and find folks and put them in jail. It's not part of my makeup or my DNA with regards to this type of piece of legislation. However, it is a paradigm shift. There's no doubt about that. This is a paradigm shift, Senator.
Thank you. Does that answer your question, Senator?
Yes.
Okay. Any other comments from other members? Can I assume that was your close?
Yes, sir.
Thank you very much. Please call the roll. Oh, I'm sorry. We need a motion. May I have Senator Hancock moves the bill?
Leno? Benoit?
No.
Benoit, no. Cedillo?
Cedillo, aye.
Cedillo, aye. Hancock? Hancock, aye. Huff?
Hutchinson, aye.
Aye. Steinberg? Wright?
The bill has 3 votes. We'll put it on call.
Thank you,
and could I ask you to give us just a moment with Assemblymember Hoffman has a
sure,
real quick piece of business,
absolutely,
and your other bill's going to take a little more time.
Absolutely.
Absolutely. With that, we'll go back to item number 11, AB 708. Deals with fish and wildlife poaching. We've had extensive testimony before. We won't review that, but we did have an amendment that you were working out. Can you give us an update?
Thank you for your indulgence, Senator. We've worked with staff and the sponsors, and we're willing to accept the amendment that would provide that the first offense for the bag limit violation would not be eligible for forfeiture, but others would. And so with that amendment, I am hoping that that will please the committee and would ask for your aye vote.
Okay, thank you. I would just represent to the committee that I think that's the amendment that the chair was looking for. He'll speak to that when he returns. With that amendment, I will be supporting the bill, and I would open the roll. Oh, we need a motion for that? Bill is moved by Senator Huff, as amended. Please call the roll.
Leno? Benoit?
Aye.
Benoit, aye. Cedillo?
Cedillo, aye.
Cedillo, aye. Hancock? Hancock, aye. Huff? Huff, aye. Steinberg? Wright?
The bill has 4 votes. It will remain on call to give the chair a chance to vote. Thank you very much. And at that, we'll return to Assemblyman Kevin De Leon, and the bill will be item 17, AB 962. Please proceed.
Thank you, Senator and Mr. Chair, members of the Public Safety Committee, for allowing me to present AB 962, my continued effort to keep handgun ammunition out of the hands of criminals and gang members. AB 962 is about closing the dangerous loopholes we have in California law that currently allows convicted felons and gang members to legally be sold ammunition. This means that today a convict or a gang member can legally walk into a store and be sold a pallet of bullets to terrorize our neighborhoods and our children. Our police officers are asked to enforce the law, but our California law doesn't even prohibit the sale of handgun ammunition to these very dangerous people. In fact, our officers simply don't even know who is in fact selling ammunition, let alone buying it. Not a single statewide agency who sells ammunition or if criminals are in fact in possession of it. That's why AB 962 would require handgun ammunition vendors to obtain a handgun ammunition vendor's license from the California Department of Justice, DOJ, to provide law enforcement a tool in tracing back bullets to their criminal purchasers. AB 962 would also require ammunition vendors to record a purchaser's identifying information. The recording of this information, as successfully done in the cities of Los Angeles and Sacramento, have helped the police departments identify and arrest criminals who have illegally purchased dangerous bullets. This model success is proven since January 2008 in the city of Sacramento alone. Sacramento Police Department discovered that 156 prohibited felons, convicted criminals, and mentally ill individuals, in fact, legally purchased handgun ammunition. That is in 2008 alone. AB 962 would also make it unlawful to sell or furnish ammunition to any person known to be prohibited from possessing ammunition, to prohibit a straw purchaser from walking to a store and purchasing bullets on a criminal's behalf. Local and state laws, respectively, require spray paint, cigarettes to be inaccessible to the public. Federal law requires buyers of certain types of cough syrups and cold medicines to show ID and sign a purchaser log. It's only logical that something that has the potential to maim and kill another human being, like a deadly bullet, be simply regulated. All that AB 962 asks is that we know who sells it and who buys it. And if you shouldn't be in the possession of it, then we give our officers and our district attorneys the tools to take it away. AB 962 has support from law enforcement across the state of California. Today, I am joined by Assemblywoman Bonnie Lowenthal from Long Beach, who also, at a very personal level, experienced when she was a city councilwoman in the city of Long Beach, the travesty of gun violence. And I'm also joined by the police officers and the police chief from the city of Sacramento, representatives from the Los Angeles Police Department, and two individuals who put their life on the line. There's Officer Wade and Officer Yap from the Long Beach Police Department. Members, both Democrats as well as Republicans, this is a very good bipartisan bill. I know I'm being very subjective in my commentary when I say that, but if you're a law-abiding citizen, you can't purchase handgun ammunition. If the bullets don't belong in your hands, you simply cannot get it with AB 962. On that note, Mr. Chair, I respectfully ask for an aye vote.
Thank you. We're going to proceed to witnesses in support. We'll take two extensive testimonies, and the remainder we'll ask for your name, association, and position on the bill. Mr. De Leon, would you like to designate who you would like as your primary witness?
Mr. Chair, I apologize. Was it 2 or 3 individuals?
2 is typical.
2 typical, yeah. Because we've had Mr. Wade, Officer Wade, and Officer Yap from the Long Beach Police Department. I would designate those 2 individuals. We have expert testimony also too from.
We have 2 witnesses from Long Beach and then Sacramento Police, so we'll allow 3, but please proceed with those 3.
Thank you, Mr. Chair. Thank you.
Thank you, Senators, for letting us speak in support of AB 962. My name is Abram Yap, and I'm a detective.
Microphone is, I don't believe, on. Yeah, let's start it again. If you would please start over.
Thank you, Senators, for letting us speak in support of AB 962. I'm Detective Abram Yap with the Long Beach Police Department. I'm assigned to the North Division Detective Detail as a field detective. We're here in support of AB 962, and we'd like to share our story and to explain exactly why we know this bill will help law enforcement officers working on the street like us. On December 22nd of 2006, an off-duty detective was in the city of Signal Hill where he noticed someone who might possibly be a gang member in a place called Turner's Outdoorsman, looking at holsters and later buying ammunition, I believe. He radioed for assistance in identifying this particular person. My then partner, Officer Roy Wade, to my left, answered up and assisted on a traffic stop. As soon as we lit the guy up on a traffic stop, he immediately jumped out of the car, pointed a handgun at us, and unloaded 12 rounds at our car in 6 seconds. That's very quick. Very quick. From the time he set foot and shot at us to the time he got back in the car was 6 seconds. So it's probably he unloaded in more like 3. Our windshield, you can imagine, it was sprayed, and I was hit twice, once in the mouth and once in the top of the head. And then I will let my partner tell him about his injuries.
Actually, I was struck by 4 bullets in the upper torso. Can you guys hear me? In the upper torso. My wounds are actually caused me to actually go in cardiac arrest. I actually passed away and was brought back to life. My subclavian vein, which is right under your collarbone, was severed, which causes swelling in your left arm, and your body is pretty remarkable. They tied it off, and apparently my veins found a different way to actually pump blood through the rest of my body. That's part of my injuries. Let's see. Oh, by the time I was struck by Gallegos in the car, I actually just grabbed my radio and I called a 999 and asked for assistance, and other people came and assisted us.
That's correct. Well, the suspect later identified as Oscar Gallegos, after he shot at us, got in his car and left, actually left us to die. And we were left there until assisting units arrived, I don't know, 40, 60 seconds later. We were just left there on the street. No one really bothered help except for one person. That's just Long Beach, sorry. Yeah, later on, Mr. Gallegos, he evaded police, was involved in another shooting, shot at 2 more police officers who were giving chase, and was able to make his way to a safe apartment and hide his car in an underground tunnel. Later, they found in his vehicle another fully loaded magazine, another high-capacity magazine. He's not allowed to have magazines that hold more than 10 rounds. He shot us with 12. He had another backup with 12 rounds, and I didn't particularly like that either. But obviously he was ready to do battle with whatever he had at hand. 5 days later, he was seen in Santa Ana where another shootout occurred with 3 Santa Ana police detectives, and he, unfortunately, or fortunately, Mr. Gallegos did not live through that fight. When we made that traffic stop, we didn't know that Mr. Gallegos was a gang member who had a serious record, including deportation and possession of narcotics was obviously one of them, and we didn't know who we were stopping at the time, and that's most likely why we're in support of this bill, because we do not want, or I do not want, prohibited people from possessing ammunition at all.
Thank you. Does that conclude your
That concludes my testimony.
Thank you very much, and I appreciate both of you, what you do, what the sacrifice and the pain and suffering, and the fact that you've come here today to express your strong concerns. Thank you for being here. We have from Sacramento Police Department, I believe, a representative, and we'll allow you to be
Yes, sir, Senators, and I'll be very brief and just kind of describe it very quickly. The City of Sacramento, at the sponsorship of Council Member Kevin McCarty, passed a local ordinance that requires the registration of ammunition within the City of Sacramento and reporting to the Sacramento Police Department. That was based on 2 assumptions. One is that those that are prohibited from possessing firearms should not possess firearms. And secondly, more importantly, in order to use a firearm, you must purchase ammunition. So we looked at it coming from the ammunition angle of it to try to take firearms off the street. That ordinance took effect in 2008, so we've had it for about 18 months. For the last 14 months in earnest, we've been working through the process. So if I can share with you the results to date. We've identified approximately 200 prohibited individuals who have purchased ammunition. Those would be prohibited from possessing firearms. We're averaging 10 to 12 a month within the City of Sacramento. We've recovered in excess of 150 firearms based on search warrants that we've served on those individuals. We've recovered tens of thousands of rounds of ammunition. 13 of those cases, because of the severity of the firearms or the backgrounds of the individuals, have been referred to the U.S. Attorney for prosecution. If I can give you 2 very quick examples. In April of 2009, we served a search warrant on a prohibited individual. His violations at the time were narcotics. In his residence in the search warrant, we found 13 guns. There were 11 rifles, 2 pistols, 2,000 rounds of ammunition, illegal drugs, and 8 homemade bombs in his possession. And you don't possess bombs just for pleasure. There was a purpose to it, and we still don't know what that purpose was in those bombs. Just an example, last week, when I asked the detective before I came here, what'd you do last week? They served a search warrant on a gentleman who has again, narcotics and some gang affiliations. They recovered 5 guns, one of which is an Uzi assault rifle. These are examples that we're recovering every single day and have for the last 14 months in this process. This bill the ordinance we have in the city is a great tool for us. It's not a panacea, but it's a tool for us to go after the guns and take them away from people who should not possess firearms. But there is a huge gap. The city of Sacramento is an island in the region, and that an example within the city can be extrapolated throughout the region, in fact, throughout the state. And so this legislation bridges that gap and fills that gap. So the same tool that we have in Sacramento can be used in Los Angeles in Long Beach and throughout the rest of the state. So Sacramento Police Department and the citizens in the community of Sacramento highly support this legislation so that the progress we've made in Sacramento can be extended throughout the state. And with that, thank you.
Thank you, Chief. Other witnesses in support, if you could state your name, who you're representing, and your position, we'd appreciate it.
Detective Richard Tompkins, LAP, Los Angeles Police Department. I'm here to say Chief Bratton and the City of Los Angeles support this bill.
Thank you very much.
Amanda Wilcox, on behalf of the California chapters of the Brady Campaign to Prevent Gun Violence. We have 20 chapters throughout the state. Many of our members have lost a loved one to gunfire. We urge your support.
Thank you.
Good afternoon, Mr. Chairman. Lieutenant Wayne Billerwood on behalf of Los Angeles County Sheriff Lee Baca. We are also in support. Thank you.
Thank you very much.
Good afternoon. Ben Van Houten on behalf of Legal Community Against Violence in strong support.
Thank you.
Kevin McCarty, the City of Sacramento. We're in strong support. Folks said when we did this we were wasting our time. We wouldn't make a difference, and we're showing that it has made a big difference in our city. Thank you.
Thank you very much.
Mr. Chair, members, Michael Corbett for Suter, Wallach, Corbett and Associates on behalf of the Alameda County Board of Supervisors in support.
Thank you.
My name is Nick Wilcox, and I'm representing the Sacramento Valley and Nevada County chapters of the Brady Campaign to Prevent Gun Violence. We ask your support.
Thank you.
Jim Lindberg, Friends Committee on Legislation of California, strong support.
Thank you. Any other witnesses in support? Okay. If we could have witnesses in opposition. If we could make, Chief, maybe you could make leave these two gentlemen here, and then that'd be fine. And then because we allowed 3 in support, we'll have 3 primary in opposition. So if amongst yourselves figure out who that's going to be, maybe we'll start with Mr. Paredes.
Thank you, Mr. Chairman. Sam Paredes, representing Gun Owners of California. It's a pleasure to be here. We'd like to start off our testimony by saying that we are in great appreciation of our law enforcement community and the officers that put their lives on the line every day to protect us. We have many present and former members of law enforcement who are supporters of Gun Owners of California and support our position. A couple of things that I'd like to point out that the good assemblyman pointed out that that really needed to be addressed in the floor of the assembly when he mentioned that he received many letters that were attacking or I don't remember exactly the words, but it was in a very negative connotation. We received copies from our supporters who wrote to the assemblyman, and all of them that we received were very polite, very to the point, and did not call him into question or his anything. They were polite and proper. And secondly, when I have pointed out in every step of the process that a registration program was in place nationwide from 1968 to 1986. It was a registration program where they recorded all of the information that is being requested in this, except for the fingerprint. Either a driver's license or a social security number was required. The make, the model, the amount of the ammunition, the name and address, all of this information was recorded and maintained in books. In California, it was very highly maybe gun dealers followed the law. Ammunition dealers followed the law. And I checked with the Bureau of Alcohol, Tobacco, and Firearms, and they pointed out that, in fact, it was the law across the country and there were no exemptions. The good assemblyman has pointed out on several occasions that it was not complied with. And on the floor, made a comment about, I had to go back to the tape to listen, the right-to-work states that just didn't comply with the law. I didn't understand what that meant, but I'm sure it was not something that was meant to be a compliment to us or anything like that. So I just needed to point that out. The main issue here is that you have a program of registration, and according to the United States Supreme Court in Haynes versus the United States, you can't even charge criminals from violating the registration of ammunition. It would be a violation of their Fifth Amendment rights. That's what the Supreme Court said. So the only people that are really only going to be charged by the imposition of this law are those law-abiding citizens who might make a mistake on their form, who do something dumb, or a dealer who makes a mistake. The testimony that was pointed out proves that the criminal issue is not going to be even really seriously addressed by this. These guys are able to bring in Uzis. What makes you think that they can't bring ammunition? Okay, so now you've got the city of Sacramento, now you've got the state of California. They can get their stuff from Arizona, from Nevada, from Oregon, and they can get it from Colombia, which is some of the places that they import some of the other stuff that they deal with in their criminal adventures. So what this kind of a program only affects the law-abiding citizens. And to come up with a tool, and I would venture to guess, because I know police officers that are investigators, that rarely is it one thing that really is the one thing that allows you to solve a crime. And to set up a program that you can't even use to charge criminals with, but can only charge otherwise law-abiding citizens, is wrong in our opinion, and we urge you to oppose this bill. Thank you.
Others in opposition.
Mr. Chairman, Kathy Lynch, representing the California Association of Firearms Retailers, the National Shooting Sports Foundation, Safari Club International, Outdoor Sportsmen's Coalition, and California Sportsmen's Lobby, all in strong opposition to this bill. Would like to just spend a moment talking about the retail aspects of this, because really this is an anti-business bill when you get right to the hub of it. The analysis, I think, did a very good job of laying out the issues, and I would point out that the length of the analysis is the cumbersome complexity of what the dealers are going to be asked to comply with. This affects a 50-round box. That virtually is the AM/PM, the 7-Eleven, the little store up in Mendocino that might sell fishing lures and a box of ammo. They're all going to have to now be registered with the Department of Justice. It's a very costly program. As Mr. Paredes points out, dealers can lose their license. If you've ever been in a sporting goods store, you will note that they're busy places and there are various clerks there, as in any retail establishment. They're going to have to keep all this ammunition behind the counter. I think most of you know that that doesn't exist today, and that would require a major retooling of their retail establishments. For a small retailer, it just puts them out of business. They're not going to have the capacity to do that. The reason that my hunting groups are opposed to this is during hunting season, retailers consistently get pallets of ammunition in for various hunting grades. People come in, they do comparison shopping, and how would you possibly be able to make legitimate purchases in the middle of a hunting season with the clerks? I think what this bill tends to do is drive business underground, drive business out of state. There's a reason that Cabela's opened in Reno. If you're a hunter, you're probably going to go up there and buy your ammunition, which means a loss of revenue from the retail perspective, but also to our fish and game funds. I think this is an ill-advised bill, maybe well-intentioned, the wrong approach. Criminals can make ammunition. They can get ammunition. This does nothing but impact the law-abiding citizen. Thank you.
Thank you, Ms. Lynch. And we'll have our third and last statement in opposition, and then anyone else who wants to identify themselves as so.
Good afternoon, Mr. Chairman, members of the committee. My name is Tom Pedersen. I represent the California Rifle and Pistol Association. I'd first like to start off with letting you know that we have empathy for our brave law enforcement officers that protect us out there. But this issue is about something that we already have an existing law for. There's a provision in law that prohibits people from possessing ammunition. There are a number of other laws that are on the books that, if were enforced adequately, I think would address this issue. I won't reiterate what's been mentioned by the previous speakers, but I'd like to just touch on the impact of this proposed legislation on day-to-day things, such as target shooters. There are a number of nonprofits that host youth shooting organizations. And the purpose of the shooting organizations, in addition to teaching safe handling of firearms, is to teach life skills. The purpose is to show children that there's discipline and other skills associated with the shooting sports. Unfortunately, what this bill would do is prevent these nonprofits from engaging in the promotion of such things, because one box of .22 long rifle ammunition, which is the firearm that most small bore rifles are chambered in, would be covered under this bill, and it would be prohibited except for exceptions for certain family members, such as a parent to child or a grandparent to a child. And in that regard, these particular calibers of ammunition are used in rifles, and the majority of rifles are chambered for .22 long rifle or .22 ammunition, and there are handguns chambered for it, but that's not the primary firearm that guns are manufactured as far as the caliber. So in that regard, it would have a huge impact on a number of activities that now occur. And for that reason and the number of other things that have been mentioned by the other witnesses, we would urge your no vote. Thank you.
Thank you, Mr. Pedersen. Others in opposition, name, affiliation.
Mr. Chairman, Ed Worley with the National Rifle Association. We oppose the bill. Can I quickly bring up 2 points that haven't been discussed very quickly, sir?
How quickly?
Very quickly.
All right.
One of them, I am a volunteer firearms instructor. I give classes to law enforcement cadets. I give classes to criminal justice students. In the provision of this bill, I cannot get a vendor's license to do this. There would be no way for me to do the orientation classes. One of the classes that I do is I have a different variation of firearms used by law enforcement that I allow the students to use. I would be in violation of the law if I allowed these law enforcement students and these criminal justice students to come to volunteer my time and allow them to shoot the firearms, because I, in essence, would be transferring the ammunition. So I can't get a vendor's license under this law because I'm not a business. I do this as a volunteer, as one of my public service duties. So there's no provision in the law for anybody outside of a business person to get a vendor's license. So all the NRA instructors that do this on a volunteer basis, our Women on Target programs, our safety programs, none of our NRA instructors who do this as a business, because they don't, can get a vendor's license to do this. The other aspect of the bill is I know some women DOs tried very hard to exempt family members, and we appreciate that. One of the things that hasn't exempted, though, is in the definition of immediate family member in the Penal Code. It does not cover brothers and sisters, in-laws, families, uncles. When I took my nephew out to do the Boy Scout merit badge program with him, I would have been in violation of the law because I gave my nephew 100 rounds of pistol ammunition to shoot.
We got the point.
So,
thank you very much,
sir.
So anyone else who wishes to identify themselves?
Charles Riglick, in opposition, bringing forth a petition of 44 citizens. It's a start petition.
Okay, thank you, sir. Anybody else? Questions, comments from the committee? Senator Huff.
Yeah, I'm just struggling with the bill on many different levels, and I think the opposition has done a good job of articulating many of the situations. I too like to go out and shoot handguns and other guns, and the whole family member thing has me a little concerned. I've got a nephew, sworn police officer. We go out fishing and shooting, and frankly, I would be in violation when I provide the ammo here. You made a comment that if bullets don't belong in your hands, you can't get it. You can't get Uzis. I mean, they can get Uzis, and those are illegal. They can get assault rifles, and those are illegal, and they will find bullets. It just happens. And so I think the fact that what we will result in is a very cumbersome policy that does keep ammunition out of the hands of those that either want to protect themselves at home or want to go out and just stay current on that, because frankly the most dangerous thing is a gun in the hands of somebody that doesn't know how to operate it. And so the more cumbersome you have for legal law-abiding people to shoot or to, you're actually making it a more dangerous situation, in my estimation. It was very compelling testimony by the officers down here, but the reality is those guys were in violation of the law. They were in violation, and nothing in your bill that I can see would have changed
the officers were in violation?
No, the criminals that they were observing were in violation of the law.
It's a plural. It's one individual. That's why.
And so nothing in your legislation would change that outcome of that situation. The ammunition would have still have transferred hands. They already had their guns loaded, most likely, when they were in that car, even before they purchased the ammunition. You also talked in your opening comment about how a person that shouldn't be having, that you're restricting here, can go out and buy a pallet of ammunition now, and there's nothing illegal about that. That's technically true. But as soon as he takes possession of it, he can buy it, but as soon as he takes possession, it's not true. And so that it's sort of a nice turn of phrase, but it doesn't hit the reality of where the illegality of owning that ammunition takes place. So there's still a point where that person can't get it out of the store without being illegal. So yeah, they can purchase it. They just can't do anything with it. They got to leave it there for the store to keep. That's not likely to happen either. I just think that this bill is well intended for good reasons. It goes way beyond the parameters of what I think the common person would find acceptable, and certainly those that are gun owners. It has some issues that have to be cleaned up, and I certainly can't support the bill today.
Thank you, Senator. Any other comments?
Let me just associate myself with most of the comments made by Mr. Huff, but
disassociate yourself?
Associate myself. Thank you. But start by again offering my respect and appreciation to not only these fine officers but others who have been put in harm's way. Many of them working for me, and I know that feeling. But I do believe that there's a point when we become really restrictive to legitimate, legal, and Second Amendment authorized activities that have a positive effect. For instance, the Scouts in many cases have a merit badge that requires that they shoot a number of rounds at a scouting event. The number of rounds involved in that merit badge would make violators of the law of the people giving them the rounds and the ones receiving them. It's overly broad. It goes beyond. There's existing statutes that I think can be enforced that would prevent the kinds of, as well as this would prevent. For all those reasons, I won't be able to support the bill.
Senator Cedillo.
First of all, both of you guys, God bless you. I'm so happy to see you. It's God's grace that you're here, and you're here for a reason, and so we're going to listen to you. And I think the goal here, the ultimate goal, all of us admire and respect you, and I think our ultimate goal here is to encumber criminals and encumber their ability to have access to ammunition. At the same time, finding a balance for people who are engaged in law-abiding activity. We want to do that. You protect us, and we want to protect you for that. But I think we have to weigh the challenges here, and so we have to look at this. We don't want to be encumbered in purchasing ammunition, but we've already stated that we will encumber ourselves in purchasing spray paint. Not accessible. We will encumber ourselves in purchasing laughing gas. We just passed a bill. You can't buy laughing gas, and if you do, and you're and somebody sells it, and they haven't made clear that they sold it mistakenly, they lose their business, and a neighborhood loses a store, and they lose credit, and they lose access to bread and butter and to eggs and milk. But we think that the balance of it is that it's safer and more important to remove that product. Last week or 2 weeks ago, we said that you can't sell Sudafed. And you go into a CVS or a Rite Aid, and there's a lot of things that you would normally be able to get. Now you got to go up to the pharmacist, or you got to go behind the counter. You got to go find a balance. And so clearly, ammunition on the streets of L.A. or Sacramento is more dangerous than a can of spray paint or Sudafed or laughing gas. And so I think we're trying to find the balance here between how we encumber and burden criminals. Encumber and burden criminals from getting access to ammunition. Yes, there's a whole plethora of ways that they can get it. A ton of other ways, and the bill is imperfect and it can't stop them all. But then the argument is that since you can't stop them all, should we not use this as one effort? Right? We heard earlier when we were going to go after every DUI motorist so that we could get the 3% that were repeat offenders. And so in this instance, we're arguing that we should go and create this somewhat burden, and I don't think the author is adverse to responding to some of the concerns that the NRA has raised for legitimate purposes, for training Boy Scouts for legitimate purposes. I don't think the author is adverse to finding ways to do that if there is a way. But clearly, in our communities, clearly the testimony of these witnesses, clearly the presence of these witnesses cries out for us to take at least this action, that at least this action should be as restrictive as we are to a can of paint, as we are to Sudafed, as we are to laughing gas. This is not a laughing matter. And this is a matter that I think compels us, with all its imperfections, with all the possibilities for criminals getting around it, for us to send a message to the criminal community. And clearly there's such an obvious link. If you can't go buy a gun, why should you be able to buy the ammunition if you're a felon? And so to the extent that we can merge these two, particularly for the communities that the Assembly member and I represent, that it's imperative for us to act on this legislation, I believe.
Thank you, committee members. I'm only sorry I missed most of the debate and presentation. I was in an hour-long presentation of a bill of my own on the Assembly side. But I want to thank the author, Assemblyman DeLeon, and his co-author, Assemblywoman Lowenthal, for bringing this forward. I also want to welcome Councilman McCarty to our chambers today and recognize the success of the Sacramento program. I think that we can learn a lot from it. From information I have, a significant number of arrests and successful prosecutions have resulted from this local ordinance. And I don't think any of us understand why it is that the level of gun violence in this country is exponentially higher than in any other Western civilized nation. It's just a culture here, and we don't quite understand why. But to agree that we can keep felons, minimally felons, putting up hurdles from accessing ammunition to make it that much more difficult, I think it's worthy of support. I want to recognize the comments relative to those who are volunteering may make some sense. You might want to look at that as the bill's moving to appropriations, though I think also with the 50 number limit that a volunteer would be able to work around this without too much trouble. And I also want to recognize the Sacramento Police Chief for your leadership and for your presence. So we have a motion by Mr. Cedillo, Senator Cedillo, and if you'd like to close, please proceed.
Thank you very much, Mr. Chair. I want to just recognize and underscore Mr. Cedillo's very articulate comments. I simply don't think I could have done a better job. I'm very sensitive and I'm very cognizant to the concerns that Mr. Huff and Mr. Benoit put forward. And to those who have historically opposed this specific piece of legislation, I have also been very sensitive to their concerns. Some things are workable, some things simply cannot work out with regards to this piece of legislation. Reference was made a few moments ago with regards to being a firearms instructor and can you pass ammunition on. And this is something that we listened to, and on page 8, between lines 21 and 24, we address that issue. We will continue to work with the opposition, but it gets to a certain point, you can go no further. As Mr. Cedillo had just mentioned, the men and women in blue, whether you're from Long Beach, whether you're from San Diego, whether you're from Sacramento or San Francisco or Oakland, they put their lives on the line every day for each and every one of us. And it is incumbent on us as policymakers at the statewide level to do everything that is humanly possible to protect them when they put their lives out there in the line for us. Mr. Paredes had made reference to some of the ill-advised adjectives that have been used to characterize my person. and the letters and the faxes. They did not receive them. We did receive them. I've been told to go back home to Mexico. I've been told to
Not from Mexico.
illegal alien go back home instead of trying to regulate the sale of handgun ammunition. Why don't we regulate taco trucks? My gender or sexual identification has been questioned also too. I don't know how that, or Mexico, or ethnicity or nationality, legal or undocumented, how that's germane to this piece of legislation. But without a doubt, at a very cultural level, it brings out the worst in people. This is a very polarizing and polemic debate, no doubt. Reference was made to the National Gun Control Act of 1968, and it was a comparison that was made to juxtapose my proposal with the failed Gun Control Act of 1968. And it was a failed Gun Control Act of 1968 that was repealed by the National Rifle Association in 1986. And it was a failed program because states throughout the nation would have to report to the Department of Treasury all the data that was requested of them via snail mail. Back then in 1968, computers, the internet, it was a thing of fantasy land at Disneyland. They didn't exist, wasn't even part of our consciousness. Was not within the realm of possibility, even though we've landed a man on the moon at the time. It just wasn't part of our reality. So when you compare this proposal, my proposal, with the failed Gun Act of 1968 at a national level, it's not even apples and oranges. It's artichokes and watermelons. And to continue to use this as an example and to do a juxtaposition at an intellectual level doesn't do this measure, I think all those individuals who are in support as well as in opposition, a great service. So I just want to thank the Chief of Police of Sacramento, who sacrificed his very important time, the fine men and women in this case, the fine officer from the Los Angeles Police Department who's made the trip up here, Officers Wade and Yap, who have come up from Long Beach, and our council member from Sacramento. But I also want to give a very, very special recognition. You did recognize her, Mr. Chair, but Assemblywoman Bonnie Lowenthal, who lived in real time the travesty that took place in Long Beach and went to Long Beach Memorial Hospital to check on Officers Wade and Yap when this happened. I was on campaign for the State Assembly. I was yet elected official. And when this happened, I remember being glued to the television set. Now, when this gang member walked into the gun and ammo store, he could very well purchase the handgun ammunition. That transaction never came to fruition. But one thing is our laws are codified and in the books. And one thing is when you have a registry, a framework, a system, a mechanism that exists that's able to capture those folks from a prohibited class from purchasing handgun ammunition. It was just by the luck of the draw that you had an anti-gang officer from Long Beach who happened to be in the store, or he trailed them into the store. And when he saw him, that's when he left and departed. And had that officer from the gang department of Long Beach Police Department had not trailed him into the store, he could have walked in and bought a pallet of bullets. And in the state of California, we have no registry, we have no framework that exists. A checks and balances, a red flag, a red light, something that says stop. You cannot sell handgun ammunition to this individual. It doesn't exist. And that's why in the city of Los Angeles have done a good job, as well as Sacramento, but they can go to Pomona, they can go to Compton, they can go Culver City and buy all the ammunition they want. I thank you, Mr. Chair, for this opportunity that you have given me. I thank the members, to Mr. Benoit and Mr. Huff. I just wanted I want to give them my word that I know the concerns continue. They have not been alleviated from today's testimony, but I will have an open door and I will have conversations, whether it's person to person or staff to staff. to see if there's anything that we can find common ground. So thank you, Mr. Chair, and I respectfully ask for your vote.
Thank you, Assemblyman, for your impassioned close. We will call the roll. We have a motion from Senator Cedillo.
We do.
Leno?
Aye.
Leno, aye. Benoit? Benoit, no. Cedillo?
Cedillo, aye.
Cedillo, aye. Hancock? Huff? No. Huff, no. Steinberg? Wright?
We are missing a few members, obviously. We're going to place this on call. We'll be lifting calls probably within the next 15 minutes or so.
Thank you, Mr. Chair. Have a good day. Thank you.
Thank everyone for joining us today. Officer. Okay. Committee members, I know it's late. Some of us are doing judiciary, which started 15 minutes ago. So we're going to conclude as quickly as possible. I'm requesting that all committee members get to our chambers because we are going to lift calls very shortly, and we won't have time to go through that process more than once. The last bill before us is item number 13, AB 807 by Assemblyman Fuentes. And the good Assemblyman is here himself, and I welcome you. Assemblyman, we have your bill, which has to do with restitution centers. Please proceed.
Very good. Thank you, Mr. Chair, Senators. I'll start by accepting the committee's suggested amendment to require the reopening of 2 restitution centers in Los Angeles County, but not specifically the ones that were closed down. I would like to add that I am aware of the governor's proposals regarding reclassification of wobbler theft offenses to misdemeanors and the potential of thousands of inmates being released. My staff and I are working closely with CDCR and understand that depending on what way those proposals go, we may have to amend the bill because there may not be sufficient population to occupy the restitution centers, if you can imagine that. However, since these proposals are still only proposals, we will retain the mandate that CDCR reopen 2 restitution centers no later than 2010-11 fiscal year. The restitution center model is an example of being smart on crime. It is based on employment that pays for restitution as well as the cost of program operating expenses. Specifically, it allows certain offenders to serve their sentence in a Department of Corrections and Rehabilitation restitution center instead of prison, where the inmate is required to work during the day to earn money to pay victim restitution and help defray the costs of his or her housing. The inmates are required to remain at the restitution center when not at work. In 2008, state officials from the California Department of Corrections and Rehabilitations abruptly closed the 2 existing restitution centers in California and suspended contracts with a community provider indefinitely, sending 74 enrolled offenders to prison and effectively denying their victims and the court restitution and fines to which they were entitled to. The Department of Corrections and Rehabilitation cited the fiscal inefficiency created by the program because 36 of its 110 beds were empty. The cost to house inmates in prison is at least $97 per day, whereas the cost to house inmates in restitution centers is about $50 per day. On top of that, a third of the inmates' income while at the restitution center goes to the cost of their housing. There are other money-saving aspects to the restitution centers that we found in researching this issue. The Franchise Tax Board's website lists its effort in attempting to recoup restitution to which it was entitled in connection with criminal convictions in an attempt to help close the state's ever-expanding budget gap. Its website cites the example of a Huntington Beach man who was convicted of embezzlement and sentenced to
Mr. Chairman, can we move the bill?
Bill is moved with no opposition.
To the restitution center with an order to repay the $99,000 in restitution. Hearing the urgency of the committee to move on with this bill, I do believe that this is a common sense bill that will ensure that more victims receive the restitution to which they are entitled to and will result in restitution, fines, fees owed to the courts that they actually be collected. With that, I respectfully ask for your aye vote.
Thank you, Assemblyman. We have witnesses in support of the bill.
One witness.
Please.
Good afternoon, members. My name is Kimberly Wong. I'm here on behalf of the California Public Defenders Association, and we are the sponsor of the bill. I have personally toured the restitution centers in Los Angeles and have spoken firsthand both to the CDCR staff present at the facilities as well as participants who have been employed, who have been paying back restitution with pride to the victims, and who have jobs or had jobs waiting for them upon their release to the community. And this is an excellent model that serves twin purposes, clearly of fulfilling the requirement of paying back victims, making them whole, but also of saving money by utilizing community settings instead of costly state prisons, where these individuals have succeeded. They've done very well. And by the way, the statistics are approximately 90 to 95% success from participants participating in this program in terms of recidivism. So we urge your support on this bill and hope that this will become a model for the state that is expanded and where we save precious taxpayer money.
Thank you, Ms. Wong. Thank you for your sponsorship of the bill. Anybody here in opposition? I don't believe we have any registered opposition. Thank you for bringing this forward, Assemblyman. I think this is a win-win-win. It's a win for the victim. It's a win for the convicted, who will have the chance in this restitution center to be able to make a more successful reentry into the community, and also a win for the state, because we're going to save some significant dollars, which we need desperately right now. So we have a motion by Senator Cedillo, and if there are no other questions from the committee, we will ask for you to make a very brief closing statement.
Very briefly, let me say that this bill retains the exclusion for serious violent felonies and offenses for which the defendant must register, and respectfully ask for your aye vote.
Great. Okay. We will call the roll.
Leno?
Aye.
Leno, aye. Benoit? Cedillo? Cedillo, aye. Hancock? Huff? Steinberg?
Aye.
Steinberg, aye. Wright?
Thank you. We will place that bill on call.
Thank you,
As you
Mr.
can
Chair.
see, we're missing some members, and I'm going to call them by name because this is a public service announcement. We're looking for Senators Huff and Benoit, Wright and Hancock. Welcome, Senator Steinberg. Thank you.
Chairman.
Would you like to make a statement?
A lengthy statement.
Please.
Yes. No. I was just wondering if we might lift the call on the De Leon bill.
Without a doubt.
That's the one that I understand is.
Is that the only one you needed for? Okay, tell me which ones. We may need you for a few others, but we'll identify those in just a moment. In the meantime, we are moving to item number 17, AB 962 by Assemblyman De Leon. If you could please lift the call.
Hancock? Steinberg?
Aye.
Steinberg, aye. Wright?
We will replace the call. Thank you, Senator Steinberg, and move on to
Item 12. Item 12. AB 750, Bass.
We're going to move on to item number 12, Speaker Bass's AB 750, which is a state opportunity for a San Francisco success story put forward by District Attorney Kamala Harris called Back on Track. Lift the call, please.
Leno?
Aye.
Leno, aye. Cedillo?
Aye.
Cedillo, aye. Steinberg?
Aye.
Steinberg, aye.
That bill has 5 votes to 2. It is out. Mr. Pro Tem, you have served your duty on this committee today, and we thank you for your presence.
I was happy to make a contribution.
That's it?
That would be item 13 and the last page. And then
We will be lifting calls first on item 17 and then 13. Item 17 again, Assemblyman De Leon's AB 962. Please.
Okay. Hancock? Aye. Hancock, aye. That's 4 to 2.
That was item 17. It's presently 4 to 2. The bill will get out. We'll put the call back on just in case Senator Wright wishes to vote. And item 13, Assemblyman Fuentes, AB 807, regarding restitution centers. Lift the call, please.
Benoit? Hancock? Hancock, aye. Huff? Wright?
That also will be out, currently 4-0, but we will replace the call. Thank you, Senator Hancock.
Yes, we did.
The first one.
No, I don't think we need it.
All right, committee members, given the time, we are just going to start with the first bill presented today, lift calls, and if bills have 4 votes, we'll move it out and close them out. So we'll start with item number 1, Senator Runner, SJR 11. Lift the call, please.
Cedillo?
No. The chair was a no.
He's got to go to no if he voted aye. You have to go to chair and recognize that vote.
Our rules are that once you are a no. I don't know. Very good.
No. Cedillo? No. Steinberg? Right.
That bill fails.
Sorry.
You abstained on it?
This was Guantanamo Bay? Yeah. So that bill fails 2-3. Item number 3, AB 91, Assemblyman Fuhr. Lift the call, please.
Cedillo?
That bill is out 4-1. Oh, yes, that's right, 4-1. Item number 2, SJR 12 by Senator Benoit. Lift the call, please.
Cedillo?
That bill is out 5-0. Item number 10, AB 653, is already out 6-0. Next bill is item 11, Assemblyman Huffman, AB 708, as amended. Lift the call, please.
Leno?
Aye.
Leno, aye. Steinberg? Right.
Chair voted 11. It is amended. Everyone has voted aye so far. Senator Wright. So that is out as amended,
Aye.
6-0. Item number 5, AB 337 by Assemblymember Torres. Lift the call, please.
Cedillo?
Chair voted aye.
Cedillo, aye. Steinberg?
That bill is out 5-1. Item 15, AB 845 by Speaker Bass. Lift the call, please.
Leno?
Aye.
Leno, aye. Cedillo? Cedillo, aye.
That bill is out 6-0. Item 18, AB 1053 by Assemblymember Solorio. Lift the call, please.
Leno?
Aye.
Leno, aye.
That bill is out 5-1. Item 22, AB 1439, Solorio is the author.
Oh, sorry. You were an aye vote on item 18? Yeah, I have it recorded as a...
Yes, you were an aye now, so now we're to item.
Item 22, lift the call, please.
Leno?
As amended, aye.
Leno, aye.
That bill is out 6-0. Item 20, AB 1166 by Assemblymember Nielsen. Lift the call, please.
Leno?
Aye.
Leno, aye.
Bill is out 6-0. Item 25 by Assemblyman Torlakson, AB 1015 as amended. Lift the call, please.
Leno?
Aye.
Leno, aye. Cedillo? Cedillo, aye.
That bill is out 6-0. That was as amended, correct? Yes, indeed. Item 21, Assemblymember Davis, AB 1369. Lift the call.
Leno?
Aye.
Leno, aye. Cedillo? Cedillo, aye.
That bill is out 6-0. Item 16, AB 951 by Assemblymember Liu. Absent members, please.
Leno?
Aye.
Leno, aye. Cedillo?
Item 16, AB 951. The vote is 5-0 right now.
Got it, yeah, thanks.
That bill's out 5-0. 6-0, I'm sorry.
Cedillo, aye.
Item 19, AB 1122 by Assemblymember Liu. Lift the call, please.
Leno?
Aye.
Leno, aye. Cedillo?
That bill is out 4-1. Item 24, AB 1516 by Assemblyman Liu. Lift the call, please.
Leno?
And that is as amended. Aye.
Leno, aye. Cedillo?
Aye. The chair, 5-0 right now. The amendment made it permissive, shall to may. Cedillo, aye.
Cedillo, aye.
That bill is out 6-0. Item 23, AB 1511 by Assemblyman De Leon. Lift the call, please.
Leno?
Aye.
Leno, aye. Steinberg? Wright? Wright, aye.
That bill is out 5-1. Item 17, we'll lift the call. That's Assemblyman De Leon's ammunition bill, AB 962. Lift the call, please.
Wright? Wright, no.
That bill is out 4-3. Item 13, Mr. Fuentes, AB 807, restitution centers. Lift the call, please. And that is as amended.
As amended. Benoit? Huff? Wright?
That's the restitution centers bill. That's the bill that expands eligibility for restitution centers.
AB 807, item 13.
Wright, aye.
That bill is out 5-0. Committee members, thank you for your patience and for your expertise and concentration. With no further business before this committee, we stand adjourned.